admissions where most of the people are under trial. If we look at the breakout of the cases in the magistrates' court, two key points here to note. The first is the number of pending cases. I don't know if you can see 770,000 pending. And at the brought forward at the beginning of the year. At the end of the year, that number has increased. The courts cannot cope. You will see below that they managed to dispose of only 24% of the cases coming in. And of those, the percentage of convictions and guilty pleas amounts to 3%. And the picture is not in other courts. This court is particularly worrying because it was set up as a speedy tribunal for the most vulnerable cases. 77% brought forward from the previous year, 77% pending. So the situation is most egregious in this country in the High Court. 85% brought forward, 91% pending. And of course, you can use these data to project going forward what will happen if the situation isn't addressed. These buckets or bathtubs start filling up. And here in the High Court, that they're almost full to overflowing. When recently we looked at the figures for 2022 in this country, the projection proved to be entirely accurate. And I'm now going to pass back to Pramita to carry on with the police.
Difficult indeed at the courts. Now, how are the police doing? At first glance, police are doing much better. They have inherited only 17% of the investigations from prior years, as you can see, and are putting forward, carrying over only 20% of their caseload to future years. At the same time, they are resolving 80% of their investigations and submitting charge sheets in 87% of the cases. This sounds very good. However, if we go back to the conviction rate in each of the courts that you looked at, in the caseload that you looked at, and if you now go to what the practitioners have said from the different institutions, sorry, just give me 1 second. That's okay. What frustrates practitioners about the justice system? And you can see who the practitioners are. So they're kind of liberally spread across the system. And the size of the bubble that you see on top is kind of the of response. And one of the biggest bubbles from all practitioners was the quality of investigations. So and I see some people nodding their heads. So this is obviously a matter of concern. Health is not the matter, but are you doing this with dedication and quality so that it actually stands up and already overburdened courts can deal with it well? I hand now back to Adam to talk about how does this all end up in prisons and what does it look like?
if you remember, we were looking at the case flow in the volume. When you look at the prisons of the average daily population was 76,000. That was already twice the holding capacity of the prison system nationally. But look at the number in a year of people passing through the prisons, almost 500,000. And you must think of prisons like a bus. If it has a capacity of 40 on a route, people will get on, people will get off. It's not static. And this number is often forgotten. And what it suggests is there's an enormous pressure on the prison administration, let alone on the effect it has on the lives of those passing through those prisons. Another way of looking at the data, and again, we've been listening about technology and so forth, it's all out there. You can cut the data in many ways. But there's a cartogram of the country with its 64 districts. Think of Zambia with your 116 districts. They could be mapped out in a similar way. And as you hover over each one, you can see figures coming up representing the figures for that district. So in terms of extreme levels of overcrowding in the country, I see almost 500% in this district, again in this one, going up to 645 and over 800% overcrowding. At a glance, you can see what's happening around the country. Let's look at two characteristics of people in prison. We see that the mean across the country, the average of people spending 6 months or less on remand, awaiting trial, is almost 60%. And again, you can hover and see how that varies across districts. You'll also see that the national mean has 30% of people in the prisons on narcotics, drugs offences, most of whom are drug users. Prisons, therefore, are forced to function as a revolving door of recidivism for primarily drug-dependent inmates with little chance of correction or rehabilitation. So back to Pramita. What are these data telling us?
This summary that you just saw of what the prisoner profile is, maybe what institutions anecdotally feel is overcrowding their prisons. But it's only this kind of data analysis that will give you this funding and allow you to move forward on what kind of decisions you want to take. So the data tells us in summary that three things are happening. Police are completing almost all of their case investigations within a year and submitting 69% as charge sheets and only 11% being rejected in final report. These cases are appearing unfiltered in already overburdened courts. So the police cases plus the cases that go directly to court, appearing in, and you saw the situation in courts, not dissimilar to the situation here. So they're appearing unfiltered in courts where the backlogs and long case durations predominate. As a result, many short-staying, low-level charged people end up in a revolving door of prison admissions and releases, disrupting their lives and burdening a prison system already straining at its capacity. Now, we've talked about courts. Let's take a very, very quick look at what the picture is like in courts. In Bangladesh, judges, magistrates per 100,000 of population the national mean was at 0.7. If you compare it with its neighboring country, India, at that time, India had about 5 judges and magistrates per 100,000. The cases, if you disaggregate that, the cases per magistrate judge would be at 1,883. These are just numbers, but you will understand this. To break through this backlog of cases, each magistrate would have to conduct 6 trial cases per court per day to make a dent in this caseload, which is physically impossible. Now, one other look at national data is at budgets, and numbers are important because let's see whether the budget is addressing the situation, solving the situation, or actually exacerbating the situation. If you go to the national criminal justice costs of that year, and remember we are looking at a year's data, 86% of the budget is going to the police and only 14% at everybody else. It would be very interesting to look at similar figures in this country, because the agency or the institution that is feeding the system, these cases we say going in unfiltered, with everything is going into courts, has the largest budget. And those which have to manage the caseload or provide support services have very little budget. So no wonder you're beginning to see this very, very distorted picture. Now the big question, what can be done?
So while human resources might be part of the problem, we've seen that if the courts continue to field all the cases sent to them unfiltered, the problems will persist. So a 3-pronged case management strategy presented itself, driven by the data. Firstly, case diversion and filtering across all stages of the justice system, including prosecution, but especially at the earliest stages where they have the greatest impact. Secondly, expedited case processing, including expanded legal representation. Again, early on where the impact will be most felt. And a concerted effort to resolve and dispose of the case backlog. So we looked, and the audit looked at a series of interventions from police through to the Supreme Court that would have a concrete practical effect. And we took a deliberately conservative sample from each intervention, 10%. If only this intervention affected 10%, what would be the impact on reducing the annual court caseload? What would be the impact on reducing the standard prison population? And of course, you can quantify the numbers, and in so doing, you can estimate savings to government. So, for example, if you take police investigation and assume that police were willing to divert 10% of minor cases, if police working with you as prosecutors, looking at the case files for weak cases to reduce charge sheet submission by only 10%, this would result in this instance, a reduction of almost 33,000 cases, and in kwacha, savings of 31 million kwacha to the courts. Take another quick example. Let's frame the charges. If, for example, the We had pre-trial review. There was to screen the cases for those weak cases, and there was greater incentive to defendants to enter pleas of guilty, again, in only 10% of cases. We'd look at reducing thousands of cases in the system at savings of estimated here 47 million kwacha. And the figures are more dramatic in the prisons. It would result if all these interventions took place with only 10%, 17% of the prison population would be reduced, resulting in 80 million kwacha savings to prisons. Duncan, sorry, did you put me into the... But so this was looking at the pressure on the courts, on the prisons in this one country, which was the overwhelming priority. In our work in other countries, what we've seen is a wider set of investment options. And we, again, with the data, put together an action matrix with lenses that would enable you to look at the gaps in a number of different ways. For example, you might be interested in human resources or infrastructure, or you might be interested in the way the stage that the case is at in the proceedings. You might be interested, as we are here, in prosecutors. And we might want to look at what it is prosecutors need in terms of human resources. Here, for example, maybe this is in Ethiopia as it happens, better security at work and at home, better offices, equipment, vehicles to reach remote areas, better coordination with the investigating office. And we've heard a bit about diversion, child justice. Maybe we need more training here. This is emerging from what the prosecutors in Ethiopia needed. Some of these might resonate with you, maybe they don't. But the gaps and your evident needs will be captured in a similar way in a justice audit. Sorry. As you get older, you become less technically proficient. Dominic. Oh, we got it. No, we've gone back to the original. Could you go back to Ethiopia? Thank you. Thank you. Thanks so much. I don't know if there are any police here. Are there any police here? No. Any prisons here? No. We're all prosecutors. And so you can view because it's such a complex area, the justice system, there may be very many ways you want to look at it. As a donor, for example, I may be interested in access to justice, or I may be interested in capacity to deliver justice. So we have to look at it in very many ways. And what do we do with it? It then gives government and you, the institutions, the ability to say, right, here's our data. All of us can get behind this because the institutions, the data comes from the institutions. And this can be brought together in some, call it a roadmap, to invite not only government but donors to get behind a concerted effort which sets out, for example, a 5-year time frame, and we can see, which is aligned with perhaps government policy or the sustainable development, the relevant sustainable goal and target. And you can benchmark with the data progress. Are we on track? Are we moving towards the target that we've identified here? Now, these are all blank because they weren't discussed with government and the institutions. But clearly, if they agreed across the system by police, prosecutors, courts, etc., we're going to get a more cohesive, more responsive justice system at the end of the day. So it helps signpost the way forward, benchmark progress towards your target destination.
One thing to reiterate here, this is not a report. This is a tool. And it's a tool that is based on your data, not data that we from GIZ or the Governance and Justice Group provide. The data belongs to you. It will always belong to you. We just read the data in a way that you are not used to reading, and we present it back to you. It provides you with a baseline to proceed, and as Adam has just presented from the action matrix, you may decide you want to start with human resources first, or you may decide that you want to increase diversion. Whatever, the decision is yours, but in the end, you will come back and measure yourselves again to see, have your decisions made the difference that you wanted it to make? In conclusion, let me use another analogy, now not from the medical sector, but from the transportation sector. Right now, the justice system, including in Zambia, is like a giant highway where everyone is on the same road, headed to court and eventually to prison, with few or no opportunities to exit at the appropriate time or place. Without building exit ramps from this highway at strategic points along its pathway, the country's justice system will continue to experience massive traffic jams, which will cost the nation time, money, and most importantly, fail to provide its citizens with the justice services they seek at the high standards that this government has set. I thank you for your attention.
Thank you very much, Adam and Ms. Pramita, for that presentation on the justice audit. That gives an overview of all the criminal justice players and give an indication or a tool that helps to introspect and see how the services are that the people receive from the institutions. At this moment, we'll allow for plenary interactions. The tool has been presented using the Bangladesh experience. Zambia can do it. I have paused so that we agree. Yes, isn't it? Exactly. Zambia can do it so that we can also have such a tool in our system and interactions. It helps us even to plan better, as usual, when you do your audit with data in every aspect. So, interactions. Any questions? I have a hand there. Mutimba. Mike?
Good
We'll get
morning.
2 questions, then we'll proceed. Yes, proceed.
Good morning. My name is Mildred Muchimba, Senior Public Prosecutor from National Prosecution Authority. My question to you is how will people have access to a web-based platform when only 50% of the population have access to internet here in Zambia? Thank you.
Okay. Any other hands? Yes, Bob. The mic.
Good morning, and thank you for the tool. It looks. My name is Bob Mwewa. My question is on two fronts. One is when you call it an audit. Usually, an audit is at the end of, let's say, a process, isn't it? So, is that how you're receiving your data? Is it at the end? Are you getting the numbers, let's say, at the end of a cycle or a yearly cycle? Or are you starting to run the tool? Let's say if you came to Zambia, you're going to start January 2026 and then run it up to December 2026 and then see what comes out. Or are you waiting for, let's say, us to run our own processes and then allow that to feed into the tool after? And then also, how do you handle the issue of different formats of data collection from different players? Yeah.
Thank you. Maybe we can have the responses for those two questions.
Yeah. Thanks. Perhaps I'll do the second one and you do the first one. Thank you for that question. No, we take the data for the year ending 31st December, the previous year. So we don't run it forward, we run it in retrospect. And how we collect the data is in various formats. You have your annual reports, I assume. We look at those, but we also collect supplementary data of important data which may not be in the annual reports. For example, the disaggregation of cases by disposal or by gender, by age. And in that way, we bring it all together, put it on a Excel sheet, and if you go on the web, and you put in justice audit, you can look at the baseline data for any of the audits, and you can see how the data, all the raw data is collected and runs across rows and rows of Excel sheets. And it's then cleaned, it's then validated by the institutions as accurate representation, not something we made up. And then it goes to the team in New York to visualize.
On the issue of internet availability, that is a very valid question, but I want to remind that this is a policy tool. So, for example, each of you as institutions collect data and consolidate it into annual data. This is not necessarily citizens' data. It can be, the government can be progressive and say, I declare the justice audit an open source. And in fact, we would very strongly encourage Zambia to do that because under the current partnership of open governance, justice will probably be one of the pillars. And this would be very, very progressive in presenting this as an open platform. However, the primary users of the audit are people who make decisions. So the National Prosecution Authority on how it will change how it deals with cases in the future or not, or police. So these are policy tools. So this is something that actually requires that institutional feed right up to the tops of institutions and less a kind of citizen feed. And maybe this also gives me the opportunity to say that when you looked at the justice audit that we presented right now, there were 65 justice audits in there. That meant that there is data for the nation, but if you click on each of the districts, you would get the same level of detail of institutional data and citizen data for that district. I hope that answers the question.
Thank you. The next round of questions. Anyone? Yes, I see a hand. That should be Miova, then the other one, Grace. Proceed.
Thank you. My name is Miyawa Ishma, Public Prosecutor, NPA. I have two questions. My first question is how will the justice audit be beneficial to us as NPA? The second question, won't this be used as part of a tool to embarrass or to critique individual institutions? Thank you.
Okay, I only have one question. My name is Grace Puri, State Advocate for the National Prosecution Authority. My question is, we've had so many reports and research studies done on our justice system. How is the justice audit report going to be different?
Thank you. We can have those three.
Again, can I address the last one first? And of course you have. And I should think you're heartily fed up with yet more research. And it'd be quite nice to see concrete change to your offices in terms of equipment or in other ways and means. The difference with the justice audit is to get beyond that, to maximize the participation of those working in the justice system, to make it as interactive as you've seen it can be. But to say, as Pramita said earlier, that these are the data you have, which we've woven together across the system. So we're not just talking about the MPA, we're not just talking about police, courts, and the various silos, but where MPA sits in the criminal justice system and how dependent you are on thorough police investigation, how dependent you are on properly trained judges to understand the evidence you're presenting. And so it links everyone together and provides what is a common data set and hopefully puts an end to some of these research studies that seem to be going on. Of course, it raises questions and we need to do more research. Why is this happening? It may point to blockages and the causes are not clear. And you will want to know more about why that is happening. But as Pramita said at the end, what it gives you is a roadmap where you decide your priorities, you decide the sequence of activities that will work for you. And that is what we would say would be the difference in terms of the report. How it benefits MPA is in like manner. It would maybe just one. Please go ahead.
I just wanted on that point draw your attention to the conviction rate that you saw in courts. That is not just a statement about court performance. That must frustrate you as National Prosecution Authority until you sit down together with the judiciary and the police to say, why are we having these justice outcomes? It's not good for people, it's not good for us. And say we have to find a process solutions. We are doing something that is contributing to that low conviction rate. It is that the courts are overburdened, but it also is that there is a very large volume of cases that are being prosecuted. Maybe they don't all need to be prosecuted through courts. Maybe you can look for other solutions for that. So these are the kind of cross-institutional findings that you only see when you look at this cross-read of data across institutions.
And just to complete on why it benefits MPA, as it benefits any other institution, is it's a very powerful advocacy tool for increasing your budget. When you look at what you're mandated to do, it is perfectly legitimate for you to say, we simply don't have the resources to do what we're mandated to do. And this gives you the evidence to say to Treasury, Ministry of Finance, properly resource us. And I think the keynote address referred to this as well. You are under-resourced everywhere. Give us the resources and see what difference we will make.
Thank you very much. Is there one more pending question? We have a guest of honor there, and the other hand I saw. Yes, then we'll close.
Thanks. I'm just curious that I see this is a 2018 audit. So were there any interventions that you put in place that were implemented, and did you see any positive outcomes? Thank you.
Well, in the instant case, we started with the survey showing that 87% of people went local. Of course, anecdotally, everybody knew that. But when they saw the evidence so graphically presented that less than 10% were going to the formal court, it reminded me of a Supreme Court judge in Mozambique who, in his rage, said, I am servicing 10% of my population. When you see the evidence, this can be transformative. What happened in Bangladesh is that there was a policy shift, effectively, to support local justice services through traditional restorative justice means, whatever. But there was a huge shift, and the money went in behind it.
And maybe also to add to that, the recognition by the Justice Minister that legal aid needed to be much more local. Classically, the legal aid system was structured to be an office where people came. But the recognition that legal aid needed to be positioned either through partnerships or through itself, much, much closer to people so they could address. You saw that bubble, the big bubble, the first order of crime experience before it escalates because it's ignored. So legal aid to be positioned as closely to the site and the size of the dispute as it could be. That was a policy flex. Yes, it's a very good question on how do we know this will not be used to embarrass governments and people. It's your choice. It's your data. If you decide to use it like that, then that's your decision. But we sincerely hope that you won't use it like that. We analyze the data and visualize it and hold your hands to a certain extent to look at what the blockages are. But the decisions of what you want to prioritize, where you want to put your time and money, how you want to come back and recheck the numbers, that's all you. So I sincerely hope that as prosecutors here and as Zambia, you will use it constructively because there is a lot of potential to do that.
Just to add a bit to that, it is partly to do with you, but also this looks at the system. It's not looking at police because everyone is part of the system. So any fault, any underachievement is unlikely to be the responsibility or fault of an institution. Some decisions will be made, as we've heard, upstream. And also, of course, we anonymize any personally identifiable information, so no one is named at all.
Thank you very much for the wonderful presentation and the responses. It has indeed invoked some discussion. I'm sure that the discussion will not end here, but we'll go further to interrogate the matter. As you are aware, when we have the figures, the data, we make good decisions and prioritize areas that need to be looked at further. So allow me to ask our two presenters to take their leave as I ask everyone to clap for them for the wonderful presentation. As we transition, we are going to the next presentation. Thank you very much. We're going to the next presentation. I'll call the two presenters for this session. It is my privilege and honor to call His Lordship, Judge. Where's my judge? Great. Thank you. Judge Mawolo Ian to come forth. And I also call Miss Wangala Iris Mwala. Yes, please come forth. Yes. We will proceed with this presentation. His Lordship is the High Court Judge from the Economic and Financial Crimes Court, Division of the High Court at Lusaka. And we have Ms. Mwala, who is the Principal State Advocate at National Prosecution Authority, and she's currently with the taxation. And you're going to and Financial Crimes Department, and they'll beam their presentation as they run us through. We'll start with His Lordship's presentation, followed by Ms. Mwala, and thereafter we can have a plenary. So IT, are we able to beam the judge's presentation? You're ready. Good. IT, as the judge comes forth, let's welcome him with loud applause. Thank you.
Good afternoon, everybody. May I take this opportunity to thank the DPP of the Republic of Zambia for extending this invitation to me to be part of this very important seminar, as it were. I have been requested to present on the topic novel practices in the prosecution of economic and financial crimes. And perhaps before I do, allow me to just ride on the protocols earlier observed so that we save on time. I realize that I'm the only one standing between lunch and everyone here, so I'll try and be rapid with my presentation. I intend to proceed by way of introduction before moving on to the role of prosecutor in combating economic and financial crimes. And then I'll look at the prevailing situation in our courts as we deal with these matters that come before us. I'll briefly pick on two lessons from other jurisdictions, basically on proportionality and on theories of forfeiture in drug-related crimes. And I will conclude by way of some recommendations. So it is a presentation on the evolving role of a prosecutor in a complex world where prosecutors are requested or are required in dealing with these matters to upscale on the existing practices as they have carried them on up to this point. And it becomes very clear from the outset to understand what economic and financial crimes are and their effect in this country and indeed in the world. The United Nations Secretariat publications of 2005 did attempt or made a definition of economic and financial crimes as any non-violent crime that results in financial loss even though the loss may be hidden or not perceived as a loss by the victims of such loss. In our jurisdiction, there also has been a definition in the Criminal Procedure Code, Economic and Financial Crimes Rules of 2024 rather, which provides that economic and financial crime has the meaning assigned to the words in the Economic and Financial Crimes Division of Court Order 2022. As may be seen, that was not very helpful in terms of making people understand what financial crimes are. And I would like to believe this is what may have led to the amendment of 2023, which kind of provided a clearer definition for all to know as they deal with these matters. But basically, the order defines it as an omission or non-violent act by a person which leads or may lead to financial loss or illegal gain, either individually or in a group, in violation of the law governing economic activity in the Republic. It is clear from the definition that economic and financial crimes cover a very wide range of offenses. And this observation was also made by the 11th United Nations Congress on Crime Prevention and Criminal Justice in 2005. It was logged down. So economic and financial crimes, as we have come to learn, include financial crimes that are committed through bank, through tax evasion, illicit tax havens, money laundering crimes by public officials, including bribery, embezzlement, and of course, trafficking offenses, which could either be trafficking of drugs or trafficking of human, which is something that is on an increase as we are seeing in our courts. In terms of legislation that is applicable for economic and financial crimes in Zambia, there's quite a bit. And of course, there's a penal code. There's the Anti-Corruption Act number 3 of 2012. We have the Prohibition and Prevention of Money Laundering Act number 14 of 2010. We have the Customs and Excise Act, Chapter 322 of the Laws of Zambia. We have also the Principal Act, which we use as a code, which is the Forfeiture of Proceeds of Crime Act number 19 of 2010. The Income Tax Act, Chapter 23 of the Laws of Zambia. The Forest Act number 4 of 2015 of the Laws of Zambia. The Narcotic Drugs and Psychotropic Substances Act number 35 of 2021 of the Laws of Zambia. The newly enacted Cyber Crimes Act number 4 of 2025 of the Laws of Zambia. The Anti-Human Trafficking Act number 11 of 2008. And of course, on that list, we might add, as we are seeing increasingly, Immigration and Deportation Act, Chapter 123 of the Laws of Zambia. What this shows is that there is no classification of economic and financial offenses in the Penal Code, but this is something to be discerned by every prosecutor seized with a matter to see where to locate it in terms of these acts that I've talked about. Therefore, in terms of preparing for their matters, prosecutors are expected to be very vigilant so that the matters they file before court are filed in the correct division of either the High Court or subordinate court. On this point, it is important to note that basically economic and financial crimes
are broadly classified either as non-conviction based or conviction based. So if you are prosecuting a conviction based matter, your point of prosecuting this matter will be the subordinate court. Whereas if it is a non-conviction based forfeiture, it will be filed in the Economic and Financial Crimes Division of the High Court. I move on to the effects of economic and financial crimes. So economic and financial crimes do cause considerable social damage. And this is because they do not only affect democratic institutions as we know them, but they also undermine the state treasury by taking away resources that are meant for the implementation of public policies as the governments carry on their work. They have a bearing on economic and financial crimes in terms of what they do to discourage investment. Investors obviously are very mindful in terms of where they locate their investments, and if ever it is known that their investment may not be secure because of these crimes that have no way of being checked, clearly that would not be a good destination for investors. Now, these crimes can be carried out by either individuals or groups of people, as we've heard from the earlier speakers. In most cases, the level of sophistication actually points to the fact that they are highly organized group with a lot of clout in terms of their connections, sometimes politically, and also they have huge financial muscles. So they are able to carry out these activities undetected sometimes. The other point in terms of what has attributed to the growth of financial and economic crimes is the technological changes that were alluded to by earlier speakers. This has complicated efforts to identify and analyze the extent of economic and financial crime, not only in Zambia, but through other parts of the world. There are actually indications that this is on the increase. Now, in terms of the role of the prosecutors in combating the phenomenon of economic and financial crimes, it is clear that Zambia and indeed the world is facing the prevailing challenge of economic and financial crimes, which are becoming more and more sophisticated globally and as time goes on. This obviously calls for us as countrymen and women to be very vigilant and aggressive in our fight against economic and financial crimes. Here is where the prosecutor comes in. The prosecutor has a unique role to play in the fight against economic and financial crimes, and this includes coming up with new strategies in the fight against economic and financial crimes. The prosecutors have a core mission to protect the community and ensure justice when enforcing the law. Over the years, before the advent of economic and financial crimes, the role of prosecutors may have been seen as being limited to that of just prosecuting criminal cases that are investigated by the police or were investigated by the police. There is a shift now because of the recognition and the need for more complex solutions that not only seek positive outcomes for victims, but also strive for long term solutions for defendants, potential defendants, and the community at large. So clearly, the role of prosecutors is not what it used before the advent of economic and social crimes, which we are having to grapple with as societies now. I am aware that the National Prosecutions Authority's vision statement is as is captured on the screen there. The prosecutor is appointed by virtue of Section 10 of the National Prosecution Authority Act number 34 of 2010, which provides that the Director of Public Prosecution may by gazette notice appoint a person as a prosecutor for purposes of this Act and Criminal Procedure Code. A prosecutor so appointed may be authorized in writing by the Director of Public Prosecutions carry out duties as set out in Section 5 of the same Act, which duties include, among others, to develop, promote, and enforce internationally comparable practice standards for prosecutors, to implement an effective prosecution mechanism so as to maintain the rule of law. We heard quite a bit this morning about the importance of the rule of law and the role that prosecutors play as they contribute to a fair and equitable criminal justice and the effective protection of citizens against crime. To conduct research into various disciplines of the law so as to study the role that the prosecution mechanisms should play in establishing effective rule of law and human rights, and to bring law in line with the developments and best practices of other countries. And I think this collaboration that we are seeing is something that is commendable, because it does encourage that we must learn from the best practices from our colleagues from elsewhere. And that is as it should be, really, because we are different levels in terms of where we are with implementation of these laws. There may be some of our colleagues who are miles ahead of us, who we can tap into from, and they too can also learn from us, notwithstanding that we may be nascent in terms of these crimes ourselves. It's a two-way process. We learn and share knowledge in that fashion. Prosecutors are required to cooperate with the police, the courts, the legal profession, and other governmental agencies or institutions so as to ensure the fairness and effectiveness of prosecution. Further, all prosecutors are expected to cooperate with the police, the courts, the legal profession, the public defenders, and other governmental agencies or institutions by virtue of Section 10 of the same Act. I am profoundly aware that to ensure efficiency and effectiveness, the DPP has further broken down the above duties in the National Prosecutions Authority Prosecutors Manual, which has highlighted that a prosecutor's duties include presenting credible evidence in court and guiding law enforcement agencies in the conduct of their investigations. It goes without saying that the prosecutor, being a person who is responsible for instituting legal proceedings against somebody who has been suspected of committing a crime, including an economic and a financial crime, is an important person that cannot be done away with. Perpetrators of economic and financial crimes are held accountable after going through the due process, which is usually through the court system, and prosecutors are critical in the court process. In my view, and from what has been shared, the law does give enough room for prosecutors to come up with new ways of fighting new challenges in dealing with economic and financial crimes in Zambia and elsewhere. As I see it, there is enough legal framework to help the prosecutor combat economic and financial crimes through their unique and very important role. That is not to say, however, that there is no room for improvement or amendment in terms of existing legislation. As we know, in terms of the law and society, society itself is dynamic, so it cannot be expected that laws will be static. What is important is to know at any given point what laws are available and how best they can be enhanced, if need be, for better carrying out of these duties. The onus clearly falls squarely on prosecutors to take up this very important responsibility and do what is mandated and permitted by the law. And obviously, this would invariably involve thinking outside the box, because these are crimes that are changing at every turn. I must say with a lot of pleasure that since the establishment of the Economic and Financial Crimes Court in 2022, and thanks to the good work of prosecutors, the state has been able to recover considerable amounts of money and other assets that had been obtained as a result of illegal activities or omission by perpetrators of economic and financial crimes. However, and I say this with a lot of due respect, some cases have been dismissed from court on technicalities, and other times the prosecution has failed to secure a conviction or forfeit assets through court process because important evidence which should be gracing the court record has not been admitted into evidence. It has been observed, and this we speak from what we see on a daily basis, that some prosecutors have scanty or little understanding of the law that they intend to rely on in terms of the cases that appear before court. In one instance, which appears to be a common instance for some reason, there was inordinate delay caused by the prosecutor in the hearing of that matter because of his or her failure to follow laid down statutory provisions. In that particular case, the prosecutor failed to give notice to an interested party in accordance with Section 30A of the Forfeiture of Proceeds of Crime Act, which led to numerous preliminary issues being raised and ultimately the case being dismissed. It has also been observed that some prosecutors have serious difficulties in having data messages admitted into evidence. It seems that not so much attention is paid to the Electronic Communications and Transactions Act number 4 of 2021. And this is important, especially now when we're living in a world where most transactions are done electronically. So clearly there will be more cases that will require admission into court of data messages. But prosecutors have a duty to understand what it is that is required before such evidence can grace a record and be useful to their cases. Briefly commenting on lessons from other jurisdictions, as the laws relating to forfeiture of assets evolve, there will come a time that in other jurisdictions to consider the concept of proportionality. Now, this is well illustrated by an American case of Timms versus Indiana, which case involved Timms pleading guilty in an Indiana state court to dealing in a controlled substance and conspiring to commit theft. At the time of his arrest, the police seized the Land Rover, which had been purchased for United States dollars $42,000 with money which had been obtained from an insurance policy for his late father. Now, the state sought a civil forfeiture of Tim's vehicle, arguing that the vehicle had been used to transport heroin. Now, in terms of the maximum accessible amount in monetary fines for that offense, it was only US dollars 10,000. So he petitioned, and his argument was that the forfeiture of that vehicle was excessive, looking at what penalty was provided for. The court, in a unanimous ruling, agreed that forfeiture of the vehicle would be grossly disproportionate to the gravity of the offense he had committed, and therefore unconstitutional under the Eighth Amendment's excessive fines clause. So these are some of issues that we may, as we go on, think about. In our jurisdiction, a situation like this would result into the vehicle being forfeited. It would be an instrumentality of crime, irrespective of what value was involved in terms of what it was carrying. So these are some of the things that are happening in other jurisdictions. In terms of the theories of forfeiture in other jurisdictions, the drug-related forfeitures would be based on one of the three theories. The first one would be about proceeds, meaning proceeds are exchanged for a controlled substance or intended to be exchanged for a controlled substance. And it is critical that these proceeds are traceable to an exchange. The second theory is one about facilitation. Basically, does it make a drug transaction easier to commit or harder to conceal? And facilitation requires that there is a substantial connection, not merely incidental. For instance, was it specifically designed or modified to conceal something, or was it designed to make the detection of that concealment difficult? These are some of the theories. The last one would be a contraband, which basically looks at whether or not it is illegal, let's say, to possess a controlled substance. So, at least one of those theories would have to be present before a forfeiture is considered. If none of these can be pointed to any intended seizure, then there will be no seizure at all. Sometimes there will be multiple, but at least there must be one of those theories. Now, every seizure of drugs requires, as I said, one of those theories to be present. An important point also is that related to money in bank accounts. If it is established that the clean money in an account was used to fund illicit activity, for as long as there is evidence that the clean money was used to generate illicit money, that too can be forfeited. And the burden of proof is based on reasonable suspicion, which must be specific and articulable. It must also be based on probable cause, which is reasonable grounds to believe, and it is done on the preponderance of evidence or on the balance of probabilities, which is more likely than not. The totality of all the circumstances is also important, e.g., trafficking quantities of drugs, admissions to engaging in such activities, and also large amounts of cash would point to some kind of criminal history. Of course, not to forget drug-related criminal history. If persons have drug-related criminal history, they may be liable when they engage in these activities, as long as there is proof. So as I conclude, it is evident to me that economic and financial crimes affect all citizens and rob the nation and the world the much needed revenue to implement different policies for the benefit of citizens. Prosecutors do play a vital role in bringing to book the perpetrators of economic and financial crimes, and also in recovering funds and properties back to the Zambian government if we limit ourselves to the Zambian government. I'm sure it is the same for the other jurisdictions. So the prosecutor, in executing his or her functions, must be alive to what is at stake here. That any mistake on their part in prosecuting economic and financial crimes in particular can lead to loss of millions of kwacha and dollars, which can only be recovered if proper and thorough preparations are done. Prosecutors are urged to take a keen interest in technological developments, as most economic and financial crimes happen in this realm, and evidence will be obtained here should the matter be prosecuted. In all this, and here I wish to echo the sentiments expressed by the National Director of Prosecutions in South Africa, that passion for the prosecutors is important. You can go through all these trainings. If you do not have individual passion to go an extra mile, you will just be one of the statistics and you will not do what must be done as a prosecutor. So passion is a driving force. Prosecutors, as I said, have to be conversant with the different pieces of legislation that provide for economic and financial crimes in order to properly prosecute any case involving the same. As I said earlier, you will not find a single statute which will tell you that this is a financial or economic crime. So you've got to be discerning as a prosecutor to know where a particular crime sits. The prosecutor is a person who knows what evidence and in what manner such evidence must be brought to court for it to be admitted into evidence, so that it can assist the court in reaching a just decision. It is therefore expected that prosecutors should be proactive during investigations of economic and financial crimes and provide the much needed assistance that the investigative law enforcement agencies, such as the police, may require when gathering evidence. I'm aware that the National Prosecutions Authority has this year launched the Prosecutors Guidelines for the prosecution of economic and financial crimes, and this is commendable, DPP. It is commendable because I think it will provide the much needed assistance in the prosecution of economic and financial crimes cases that grace our courts. The prosecutor, in my view, has all the necessary machinery to enable them, that is him or her, execute his or her duties most diligently and expeditiously. The question that remains is, will he or she use it? So this is an individual question where we are all seated. Let's ask ourselves, will we use the tools that have been made available to us to do that important job which we do on behalf of the millions of Zambians who have entrusted us with this responsibility? In saying, as I have done, I must not be understood to say that prosecutors must secure convictions or forfeit all properties at all costs. That is not your role. Your role ultimately should be about aiding or assisting the court to arrive at a fair and just decision, which is what is the role of adjudicators as neutral umpires. I thank you most sincerely for your kind attention.
Good afternoon. Allow me to ride on the protocols already observed. So my presentation is on the novel practices in the prosecution of economic and financial crimes. Judge has given a very elaborate presentation. So in the interest of time, I will go straight to the novel practices. So one of the novel practices in the prosecution of economic and financial crimes at international level is the establishment of specialized courts and tribunals. Examples of such courts are the anti-corruption courts in Albania, Afghanistan, Botswana, Kenya, Tanzania, and Uganda. You may also wish to note that there's a proposal to create an international anti-corruption court that will specifically prosecute such matters at international level if accused persons are not prosecuted in the countries of origin. These courts provide a dedicated forum for prosecuting economic and financial crimes, thus ensuring expertise and efficiency. I'll proceed to the next novel practice. Another novel practice internationally is international cooperation. So economic and financial crimes by their very nature are transnational most of the time. And it is therefore important that different countries collaborate in the prosecution of these cases. So we have international organizations like the Financial Action Task Force, or FATF, the Egmont Group of Financial Intelligence, and the United Nations Office on Drugs and Crime that play a vital role in promoting global cooperation. Another important aspect of international cooperation is the use of informal platforms. So one of the platforms that we have is the Globe network, where different institutions can cooperate informally. Through international cooperation, information which is vital to the prosecution and investigation of these crimes is easily obtained. Another novel practice at international level is the use of open source registries. Investigators and prosecutors can use these sources to obtain information from a range of countries without the need for mutual legal assistance. So you can easily access open source information. For example, if you're investigating a case, you can Google and you get information on the case that you're investigating using open source registries. So these are very, very important tools in the investigation and prosecution of economic and financial crimes cases. Internationally, another important strategy, which is novel, is civil asset recovery, which is popularly known as civil forfeiture. So this is a process where assets are seized and forfeited to the government without a criminal conviction, thus depriving criminals of their illicit gains, and this deters future criminal activities. So traditionally would forfeit assets after a conviction, but now there's this move towards civil asset forfeiture, where you do not have to get a conviction before seizing assets that were illegally obtained. Another novel practice with relation to the prosecution of economic and financial crimes cases internationally is plea negotiations and agreements. So basically what happens is that in exchange for the accused person pleading guilty, the prosecutor will agree to certain concessions, such as reduced charges and dismissal of some of the charges. Okay, so these help both parties to save time and avoid the expense of a full trial. I'm sure you're aware that most of the economic and financial crimes cases that we prosecute, can be very complex and bulky. They can take a lot of time to prosecute. So this is a very, very effective tool in the prosecution of such cases. So you find you conclude a case within a week that would ordinarily have taken you a number of years to prosecute. So it's one of the novel practices in the prosecution of economic and financial crimes cases internationally. I'll move to the Zambian perspective. So basically, as a country, we've used all the strategies that I've highlighted in the prosecution of economic and financial crimes that have been used internationally. But I'll just zero in on the practical aspect of how we are doing it in Zambia. As the previous speaker, His Lordship, mentioned, with regard to the establishment of economic and financial crimes courts, in 2022, the judiciary created a new division of the High Court, that is the Economic and Financial Crimes Court, pursuant to the Economic and Financial Crimes Division of Court Order of 2022. And at subordinate court level, the court was created as a division by the Subordinate Court Amendment Act number 23 of 2023. So basically, the Economic and Financial Crimes Court is a specialized court established for the sole purpose of adjudicating corruption and economic and financial crimes cases in Zambia. In 2024, the Criminal Procedure Code, Economic and Financial Crimes Court Rules, that is statutory instrument number 10 of 2024, was promulgated, and it came into operation on 1st March 2024. So according to the rules of that court, matters in the Economic and Financial Crimes Court must be determined within a period of 5 months from the date plea is taken or the appeal is filed. However, the rules provide for an extension of time within which to conclude these matters, which should not exceed 45 days. However, I've cited a case there, the case of Citibank Zambia Limited, which is a case that we use when we are faced with arguments from the defense that time has lapsed in the prosecution of these cases. So basically, failure to comply with the duration set under Rule 3 is not fatal as guided by that case. So for us as a country, we've set a certain time frame for the prosecution of these cases so that they are prosecuted expeditiously. Another novel practice that we've done as a country is that the National Prosecution Authority has established specialized departments to prosecute economic and financial crimes. So we have the Taxation and Financial Crimes Department, my department, and we have the Asset Forfeiture Department. So the Taxation and Financial Crimes Department prosecutes white collar and other general commercial crimes, corruption and drug cases. So basically economic and financial crimes. Then the Asset Forfeiture Department is mandated to implement the provisions of the Forfeiture of Proceeds of Crime Act number 19 of 2010 by fighting crime through asset recovery. So the establishment of these units has been very instrumental in the prosecution of economic and financial crimes, as now we have experts that are dedicated to the prosecution of these cases. Another novel practice in Zambia is non-conviction based forfeiture. So sections 29 and 31 of the Forfeiture of Proceeds of Crimes Act that I earlier alluded to provides for non-conviction based forfeiture applications. So these are basically civil forfeiture applications. So this tool enables authorities to seize and forfeit assets without a criminal conviction, providing a powerful tool for disrupting criminal entities. That's some pictures of the type of things that we forfeit, like houses, vehicles, and money for your viewing. Another novel practice that we have implemented in Zambia in the prosecution of economic and financial crimes is interagency cooperation. So in 2023, the National Prosecution Authority created the National Task Asset Recovery, which is popularly known as agency framework as an interagency forum to collaborate and coordinate the investigation and recovery of proceeds acquired from illicit financial flows. So the interagency framework comprises 21 institutions. These are law enforcement, regulatory, and prosecutorial agencies. So we've come together to fight economic and financial crimes. Under the interagency, we conduct what are called prosecutor-guided investigations, where the prosecutor is involved in the investigation of cases from the onset. And this has helped the effective investigation of these cases and has also reduced the turnaround time. So before these prosecutor-guided investigations, cases would take long to be concluded at investigation stages. What would happen is an investigator would investigate a case maybe for a year, submit it to the prosecutor will go through the docket, send it back to the investigator just like that. But now you sit with the investigator from inception, and this has reduced the time in which these cases are investigated. Some of the cases that have been investigated through the interagency are the famous Egyptian gold case and the Indian gold case, which occurred at the Kenneth Kaunda International Airport on 14th August 2023 and in April 2025, respectively. And the assets in these cases were successfully seized and forfeited. Another novel practice in the prosecution of economic and financial crimes cases in Zambia is the use of registries. So we have a number of registries in Zambia, such as the Lands and Deeds Registry, the registry at the Patents and Companies Registration Agency, and the Road Transport and Safety Agency. So our investigators normally go to these registries to conduct their investigations. You'll be amazed at the things that are discovered at these registries. This is where we discover how many ports someone has, how many vehicles somebody has, and how many companies. And it also helps in ascertaining the net worth of the accused persons. So these have been very, very helpful. In Zambia, we've also used the novel practice of plea agreements. I've cited two sections there. That is Section 4 of the Plea Negotiations and Agreements Act of 2010 and the Section 68 of the Anti-Corruption Act. These have been very, very helpful. Like I said, plea negotiations are a useful resource. They save on time, and you're able to forfeit properties without going through the full trial. So these have been very, very helpful. In my presentation, I've highlighted some challenges and recommendations. So some of the challenges are financial constraints. Like I said, economic and financial crimes, by their very nature, are very complex and usually transnational. So they require a lot of resources, especially during investigations. There's one matter that we recently prosecuted where the investigator had to travel as far as Turkey and Congo just to obtain information, and that requires a lot of resources. So financial constraints are one of the challenges. Another challenge is inadequate human resource. Like I said, these cases are quite complex and they require capacitated human resource. Finally, with regard to the challenges, we have inadequate court infrastructure. So I'll give an example. At subordinate court level, we currently have over 20 magistrates with only 12 courtrooms. So this has posed a great challenge to the prosecution of economic and financial crimes and greatly affects the rate of disposal of these cases. With regard to recommendations, I've said increase funding to investigative agencies, prosecutorial agencies, and the judiciary. So these will deal with the issue of the financial constraints and inadequate human resource. Another recommendation is continuous capacity building. So economic and financial crimes are ever evolving. You cannot have adequate capacity building. You can never reach a point where you say, okay, now we're adequately capacitated. So there's just need for continuous capacity building.
In conclusion, the prosecution of economic and financial crimes requires a multifaceted approach that incorporates specialized institutions, international cooperation, advanced technologies, continuous capacity building. By adopting novel practices and strengthening these practices will promote a culture of accountability and transparency.
Thank you very much for those insightful presentations. At this juncture, I'll call upon any person who has any question to ask the panelists. Any question? I see two hands. I'll allow two questions. Yes, the lady there. Where is the mic?
Thank you for the wonderful presentations. I'm Josephine Gwaza from Malawi. I'm wondering what has been the overall impact of the legislative reforms. I have in mind the amendments that were made to the 2010 Forfeiture of Proceeds of Crime Act, as well as you talked about the creation of the Financial Crimes Court, as well as the updating your framework on interagency asset recovery. What has been the overall impact of these reforms here in Zambia? Thank you.
There was another hand. Oh, okay. We'll get those, then we can have the panel respond.
Thank you. I have one question. What measures does NPA takes on properties that are forfeited to the state around the country, especially buildings, land, and motor vehicles? Because some of these properties, they're just accumulating dust and depreciating. Thank you.
Yes, so we'll have those two questions responded to.
Thank you very much for your good question in terms of impact of the reforms in Zambia. One of the great impacts, in my view, in terms of the creation of the Economic and Financial Crimes Court, is that this is a court that is dedicated to dealing with specifically economic and financial crimes matters. So because of that, there is a good amount of specialization that has come into this court. Secondly, when you talk about the amendments to the existing laws, they are getting refined as we go on. And one of the greatest amendments has been the requirement for matters to be disposed of within 5 months, as indicated by the other presenter here. In other words, this is a fast track court. And because it is a fast track court, we have moved away from situations where matters will go on for years on end. I'm sure a lot of us, especially in this jurisdiction, will relate with matters that were before courts for a very long time before seeing conclusion. So with these changes now, I can bet you that matters are getting disposed of at a very fast rate because we have rules by which we must operate. And we tell even litigants who appear before us that we are a fast track court. And because of that, even adjournments are sparingly given. you will only get an adjournment with a very convincing reason. Otherwise, prosecutors who have appeared before our court will tell you that maybe they think we are mean, but no, it is because we must deal with these matters and bring them to their conclusion one way or the other. It is not fair for the persons whose properties, for instance, are in court, for those matters to be in court for a very long time, only for them to be handed back years later in a state that may not be as great as they were at the time they were restricted, for instance. So those are some of the changes that have occurred as a result of those changes in the pieces of legislation. I'll let my colleague add on.
Thank you, Your Lordship. In addition, because of these strategies, we've seen a remarkable reduction in the incidence of corruption. I'll give you an example. The trends report by the Financial Intelligence Center for 2024 that was recently released shows a drop in corruption cases, and we can only attribute it to these strategies that have been put in place. So we've seen some changes as a result of these interventions. With regards to the question about forfeited assets, there's a committee of survey that has been put in place that is looking into all forfeited assets. So I'm sure that issue that you raised will be dealt with adequately. Thank you.
Thank you very much. Join me in thanking the panelists for the presentation and the responses that they have given. We are now transitioning into another segment of our conference, and this is called lunch. So we will go and feed and come back after an hour. But before we go, a few housekeeping announcements. Firstly, if you haven't seen where the program is, please just check your the badge. There's a QR code on it so that you check for where we are going next. So we'll have continuation of the sessions, but will not all of us be here. So we will have sessions, 3 sessions at a go. They will be at the same time. One will be here, then 2 will be in rooms called AG09 and AG08. They are, as you are coming into this building from the car park, that's where those 2 rooms are. So we'll have sessions, panel sessions there and one here. So when you look at the program, you will decide which panel or which session to go for. Then after that, around 15:40, once the panels are done, we'll have to come back here, all of us, for one last session. But because we didn't do one session where we are talking about asset recovery, we will have that one squeezed in so that we have 2 last session here. And with your indulgence, which I can see you've granted me, that instead of us knocking off or going for tea at 16:20, we'll extend to about 16:45 so that we can conclude the business of the day today. Agreed? Thank you very much. You're wonderful people. Now, as we go for lunch, I will request that the ushers will guide our VIP, that is our guest of honor, the international delegates, all heads of institutions, and the NPA board chair and the members, the CASA present, including the PSA, to go and have lunch in the lounge that the ushers will guide using this room here. Then for the prosecutors from other institutions and senior state advocates, will have the lunch set out just outside where there is on the first floor there. There will be an area that has been set out and ushers will guide. The reason is that we need to quickly have our lunch and come back. That's why we have many areas where we can feed from. Then we have all state advocates and prosecutors and other staff that will be on the first floor. The lunch has been set up. So we will proceed in that regard. Thank you very much. We can now go for lunch.
We're just breaking up. I wanted to introduce you. Okay, you're welcome. Thank you. You are still.
Best sunset views in the world. Memorable game viewing adventures in the small but well-stocked Motiotunya National Park, where you can see the rare rhino. Experience the best of Zambia's rich culture and history at the Livingstone Museum. Or through visual and performing arts, food and folklore at the bonfire by night. And to crown them all, the awesome, majestic, mighty Victoria Falls, one of the 7 natural wonders of the world, known in local language as Mosio Tunya, the smoke that thunders. A visit to Livingstone is incomplete if it does not include this world-famous icon. Some call it Zambia, but we call it home. One Zambia, one destination, limitless exploring. Zambia, let's explore. Breathtaking and thrilling. Visit Livingston City for pure adrenaline and fun. Let its thrills and spills inspire you. Livingston features arguably the best sunset views in the world. Memorable game viewing adventures in the small but well-stocked Motiotunya National Park, where you can see the rare white rhino. Experience the best of Zambia's rich culture and history.
World is a living tapestry, woven from diverse cultures, each with its own story, history, and tradition. In every fold, every stitch lies pride, identity, and belonging. From the vibrant hues of African robe to the delicate patterns of the Asian sari, clothing tells the stories of where we come from, what we stand for, and the values we hold dear. In the world of law, this diversity isn't just seen, it is felt. Our laws may differ, but the core principles remain the same.
Testing 1 2 1 2.
Yeah, so it's just they put the screen there.
Excuse me, Mr.
Mr. Nkwachu? You just switch it. So this is it's a bit too far.
Do you have somewhere to see your results?
Okay. So you could choose again this for just switching to the So we just wanted to give my mind will just it's very easy to I know, but it's instructive for me. I can't even see what's okay. The only problem is if it's coming from that side, you won't be able to. Okay, just leave it then. But I will use it. Yes. Are you from SCC? No, no. Okay. NPA. Ah, NPA. That's all the time I got to meet and you're from NPA as well? Yes, I'm a state advocate in one of the departments. Yes. No. Okay, yeah.
Good afternoon, ladies and gentlemen. May we please settle down? We're about to start the session. Welcome to the afternoon session. allow me to ride on all protocols already established. Jacqueline Banda, your moderator for this session. The topic for this session is reimagining the fight against corruption, modern and advanced strategies. Corruption remains one of the greatest obstacles to social justice, economic development, and democratic governance. The government of Zambia is fully committed to the principle of zero tolerance to corruption. However, to truly defeat corruption, we must reimagine the fight against corruption through modern and advanced strategies. To unpack this topic, allow me to introduce our speakers or panelists for this session. Ms. Dankwachi Kanyimbo, Assistant Director, Legal and Prosecutions at the Anti-Corruption Commission, with 11 years post-admission as an advocate of the High Court, and also Mrs. Priscilla C. Chanza, the Chapter President and Board Chairperson for Transparency International Zambia. She has also okay. Um, Allow me to say that there are two other parallel sessions that are taking place at the same time in the other rooms. So those who would wish to go to the other sessions are at liberty to do so. It's not only this session, but I'll still continue with the introductions. I was saying our next speaker is Mrs. Priscilla, the chapter president and board chairperson for Transparency International Zambia, and she has over 20 years experience post admission as an advocate of the High Court. A round of applause for our two speakers, please. I will now call upon Mr. Nkwashi Kanyimbo to give us his presentation. Thank you.
Distinguished ladies and gentlemen, good afternoon. So that is the topic I'll be presenting on, reimagining the fight against corruption in Zambia, modern and advanced strategies. And in my presentation, I'll give a brief introduction. Thereafter, talk about technology, whether it's a threat or a tool. Then from there, we'll move to modern and advanced strategies that we can use in combating corruption. And I'll conclude after. So corruption is one of the white collar crimes that is complex due to its evolving nature. And today, corruption has evolved from being petty bribery to complex procurement fraud, grant corruption, and digital enabled corruption. Further, when we talk about high profile cases or grand corruption, The actors involved are usually officials who are academically highly qualified. Therefore, they're even able to think carefully as they commit these offenses and try by all means to cover their tracks. Consequently, for the fight against corruption to be effective, there is need to use modern and advanced strategies in the fight against corruption. This is because public or private officials who usually get involved in grand corruption knows even what the law enforcement agencies look for during investigations. And in most instances, they'll even try to avoid leaving a trail of evidence or cover their tracks. Therefore, as corruption keeps evolving and corrupt actors keep learning different ways of committing white-collar crimes, there is a great need to keep reimagining the strategies used in the fight against corruption. Now, the question that begs an answer is technology a threat or a tool? So we cannot talk about modern and advanced strategies of combating corruption without talking about technology, considering the fact that today technology has advanced more than it was few years ago with the innovation of artificial intelligence. Consequently, the question that begs an answer is whether modern technology is a blessing or a curse. A tool for investigation and information gathering, or a threat. Imagine someone hacking or using anonymous platforms to log into our electronic systems and alter records, be it financial investigations or even your title deeds, since now we are also going electronically with title deeds, or erase evidence of corrupt conduct, money laundering, or leaks confidential information in exchange for money, or simply gets confidential information and threatens to say, if you do not pay me, I will release this information to the public. Is it a tool or a threat? So therefore, as we embrace modern and advanced strategies, we need to carefully deal with technology, which is a double-edged sword, and if not properly handled, can be used or a facilitator for commission of white-collar crimes, and at the same time, we can use to detect and prevent commission of offenses. So when we talk about modern and advanced strategies in combating corruption, so as a country, we started reimagining the fight against corruption a few years ago and have made some achievements by the introduction of the e-governance services and e-government procurement, which has reduced personal interaction in service delivery and face-to-face bribery. Further, we now have the online anonymous whistleblowing system, which has improved the protection of whistleblowers in the sense that no one will know the identity of the whistleblower, as the system will only generate an ID number which will only be known to the person making that complaint. With this system, a complaint can be filed 24/7 and anywhere in the world without using the traditional way of coming to the commission for you to lodge a complaint. Further, the use of investigative tools such as GoCase, which is a case management system, with it you're even able to do analysis of financial records. We equally have the OpGen, which is a tool that is used to retrieve information from electronic devices, and thereafter a report would be generated as it was presented earlier on. So, with these few strategies, are these enough, or we can do better? The answer is that we can do better. And in doing better, the other strategies that can be used are to mitigate and minimize corruption by combining prevention, detection, and robust response, which entails, among other things, having strong policies for anti-corruption and also having processes relating to sensitive information and data, considering the fact that in the past it has been the position of the government to go paperless. Hence the need, which led to introduction of Smart Zambia and e-governance services. So we need to have systems that will be strong enough to protect our data, considering the fact that most of critical information, which now even includes ownership of land, is being stored electronically. And if our systems are weak, we're in trouble. Further, we're saying vetting of particular staff in key positions. So we need to reach a position where strategic positions or senior positions in public institutions as well as private sector, one needs to be vetted before one is appointed in such a position. Further, strong whistleblowing mechanism, which among other things requires us to amend our current Whistleblowers Act. That act was enacted in 2010. To date, it has not been amended. So in order to strengthen the protection offered under that act, there is need to amend it so that we have strong whistleblowing protection system. Other strategies will be having covert and effective financial investigations, as this will allow the law enforcement agencies to conduct thorough investigations without undue pressure from the interested parties. The danger with investigations is that the moment the public is aware that this person is under investigation, few months later they will be demanding for the status. What is the position? Where are you? So to avoid such pressure, it is advisable that we do conduct covert investigations, which should then give the investigative wings sufficient time to investigate and follow the money. Further, effective and thorough intelligence gathering strategies before taking coercive action in order to avoid jeopardizing cases. Effective and thorough intelligence gathering, especially in financial crimes coupled with lifestyle audit. We should be able to conduct a lifestyle audit without even the suspect knowing. So that at the end of the day, should we find anything wanting, the necessary steps should be taken. But if we rush to go to the public, you may end up losing a case we could have won. Further, having investigative strategy with timelines and perimeters, as this will prevent wasteful investigation or developing weak cases. Hence the reason of having prosecution-guided, prosecution-led investigations, so that investigations are legally guided to avoid gathering of unnecessary or unuseful information or evidence. This entails that once you have a complaint or once you are investigating a matter, we should be able to know what is it that we are looking for. It should not be an open check, where when you go to Mr. A's office, you end up correcting every document in that office. We need direction and set timeframes, notwithstanding that financial crimes are complex. The longer we take, the higher the chances of us losing our witnesses and good evidence. Further strategies could be catch them while they are young or teach them while they are young. So this is referring to our children in schools. They say you cannot teach an old dog new tricks, eh? So whilst they're still young, let the children start learning about corruption issues. And this, ladies and gentlemen, it's being done right now. Through collaboration with the Ministry of Education, we now have in the curriculum for the children, starting from primary school up to tertiary, subject to do with corruption. Most further, we also need to have visionary leadership and continuous capacity building. Visionary leadership. If it was not for one man's vision, we could not be here today. This is an example of a visionary leader who thought of doing something in a different way. Hence the reason we've assembled in such a man. So for us to fight these white-collar crimes, we need people to lead with vision and a direction, not as business as usual. If the corrupt ones are not committing crime as usual, they're innovating, they're changing, what about you who's pursuing them? So we need leaders, we need investigators, we need prosecutors with a vision. And equally, we need to build our capacity. Earlier on, we were told that the capacity need not to be institutional. It can even be at an individual level. Are you passionate about your job? Are you willing to be better than you are today? If not, dare to try. Further, we need to grow public awareness and civil society engagement in anti-corruption efforts. Civil society engagement, stakeholders, participation, this is needed. And we need them to offer support and not control. Support, not control. Growing public awareness. You'll be surprised that people in Shangombo do not even know what corruption is. The people involved in IFMIS, they may not even know. Someone will tell me, how many bags of fertilizer are you getting? Oh, you want 4? Okay, I'll put the 5th one in your name. Then when that person is not able to pay, they pay for them and they grab everything from them. But if you pay them a visit, they will have. So Zambia is not just Lusaka and Copper Belt. We need to go deeper and let people know the do's and the don'ts of people in public office. And lastly, we need to promote a culture of integrity through training officials and stakeholders on ethical conduct and anti-corruption measures, among others. And in codifying, as corruption continue to evolve, law enforcement agencies need to continue developing and implementing modern strategies in the fight against corruption. We need strategies that will promote transparency and openness, strengthen enforcement of the legal framework, and foster a culture of integrity by having structures or strategies that promotes ethical conduct and anti-corruption measures. Remember, a corruption-free Zambia begins with each one of you. Asanteni sana.
Thank you very much. We call on Mrs. Chansa to come and give her presentation.
Good afternoon, everyone. I'm speaking in my capacity as Transparency International Chair and not as a lawyer. So I'm speaking from the civil society perspective. As you are aware, Transparency International is a member of the Transparency International global movement. And we're involved in the fight against corruption and good governance. So it's a global movement. So with that, I think I can start my presentation. Jacqueline? I need this to move. Okay, thank you. It's not moving from my end. Yeah. Oh, thank you. Thank you. So Transparency International, well, there's the basic outline of the presentation for everyone to see. I'm not going to go through that. So basically, I'll go through right into the body of the presentation. So as Transparency International, we define corruption as an abuse of interested power for private gain. So corruption is basically a consequence of lack of integrity among people who have been entrusted in a position of authority or power. So we'll be looking at it from that perspective. As TIZ, in our own strategic plan, actually, we've identified the core problem of corruption as a weakening integrity among individuals, public officers, and communities, leading to worsening levels of corruption in Zambia. I'm sure a number of you've experienced a situation where, yes, you're prosecuting a matter, but the family's victim actually come to you to offer you something. Not that you've requested for it, but because that is the culture that we've created among ourselves, that I need to give you something for you to do your job. And that's what we are referring to. So in resolving the problem and the consequences of high levels of corruption, it also requires implementing modern and advanced technologies and solutions. This presentation, therefore, seeks to reimagine the fight against corruption in Zambia by exploring modern and advanced strategies in doing so. So the importance of modern technology in fighting corruption cannot be underestimated. Globally, governments, activists, and civil society are turning to information and communication technology as essential tools to promote transparency and accountability, as well as to identify and reduce corruption. Fighting corruption should modernize or it risks being dated. You cannot fight corruption now without involving or implementing technology in the tools that you use, whether to identify or monitor the levels of corruption. So I'll give you an example. Research models, that is globally and Zambia inclusive, have actually projected that digitizing government payments in development countries could save roughly up to 1.1% of GDP. That's equivalent to 320 billion annually. So you can imagine the impact of corruption on our economies, especially as developing countries. This is why you've noticed, even as Zambia, our own country, we've moved into e-governance, e-procurement. Even when you talk about the Ministry of Lands, there's digitization. But of course, those things come with their own risk. So in terms of technology, in anti-corruption actors, we actually envisioned a techno-integrity utopia. That's what we're calling it. This is an idealized society where the combination of advanced technology and enhanced integrity levels lead to a state of near perfection in terms of trust, transparency, and accountability. The other tool that is actually being used in advancing modern technologies is artificial intelligence and machine learning. I think AI, everyone somewhere has to use it. So usually AI in terms of anti-corruption is used for real-time monitoring, corruption risk scoring, and pattern detection. It's also used for advanced data analytics using AI, which can support the review of large volumes of data, revealing patterns of corrupt activities and informing decision making. I'll give you, for example, the utilization of AI in certain jurisdictions. what actually happens is you can actually see a pattern which emerges from fraud related transactions that involve mobile money and financial sector. What you'll notice is that you can actually even see the demographics, the age group of people involved, the areas where those activities are rife, the gender. So it makes it easier for the people that are prosecuting when gathering evidence for the investigators to actually see what kind of interventions can actually be employed. Because the issue with corruption is not about just fighting it. You also have to look at the preventive mechanism. And I think as developing countries, there's more that we can do in preventing than in actually fighting. So when data from different sources are connected, it becomes easier to understand corruption risks easily and act with greater precision. Therefore, AI can aid law enforcers and prosecutors through automated document review and evidence gathering. For example, as TIZ, we are integrating AI in analyzing parliamentary transcripts in order to monitor the performance of members of parliament. I'll give you an example. There's some members of parliament that have been in the house and have just said, hey, how are they representing their constituents? So we want to understand, what is this member of parliament submitting? How is it what they are submitting relevant to the challenges of the community that they are representing? So we'll be able, once we have the transcript, to say which member of parliament was quiet throughout the session of the House. When they said, what did they say? Was it relevant? Are they providing solutions? Are they being representatives to the constituencies that they represent? So you'll be actually able to see how you can match this data. So as prosecutors, you can utilize that tool to ensure that when you're prosecuting your matters, you'll be able to get the intended results. Of course, members of parliament won't be happy. So digital forensics and blockchain technology, this can be used to create immutable and transparent ledgers for transaction in government procurement, supply chain monitoring, and identity management. It's also useful for enhanced beneficial ownership transparency. I'm sure when you read the financial intelligence report and you see the issue of illicit financial flows, you correlate them to some of these shell companies that are operating. And sometimes it can be a challenge to actually get to the bottom of who the beneficial owners are of that institution. So when you use this digital forensics and blockchain technology, it really gets to help you to actually get to know who is benefiting at the end of the day. Digital forensics and blockchain can therefore aid information exchange and speeding up of investigations. For example, the World Bank Governance Risk Assessment System uses analytics to uncover fraud in public procurement, with pilots already underway in Brazil. So I spoke about preventive measures and advocacy for fighting corruption because as TIZ, we are cognizant of the limited resources that we have to prosecute corruption matters. What we're saying is, instead of focusing on merely prosecuting, we're saying we can also do a bit more in terms of preventive measures. For example, anti-corruption actors must also embrace other advanced strategies in fighting corruption. These include measures to prevent corruption, money laundering, and illicit financial flows, as well as proven advocate strategies aimed at promoting legal and policy reforms and improving transparency and accountability in the implementation of public policies and programs. Zambia can take advantage of the following preventive measures. Strong and independent oversight institution. We are happy, and we must say that we've seen a lot of financial support in terms of budgetary allocation to oversight institution. So would want to see more of that, not just financial, but even in terms of autonomy. My colleague already made mention of declaration of assets and liability. It's a good tool to monitor how is someone moving from having 500,000 when they're getting into office to living with 20 million kwacha. We just want to understand, because we know what their salary is. We just want to know that there are no conflicts of interest, there's no abuse of authority where they end up taking advantage of their position for their private gain. Lifestyle audits, effective whistleblower protection. I think my colleague made mention of the anonymous whistleblowing, online facility that SEC has, public access to information, independent auditing of public expenditure, and conducive legal and policy frameworks. So I think as a country, we can take advantage of the international commitments and conventions that we've ratified as Zambia. We talk about the UNCAC, which is the United Nations Convention Against Corruption, and the EU Convention, because these conventions, from time to time, their peer review mechanism or the periodic reporting can actually influence government reform. So if you look at the UNCAC has got various provisions. And I think for prosecutors, what could be of interest is sharing of technical assistance, international corruption, international support in terms of cooperation. We are all cognizant of the fact that corruption is now transnational. Corruption involves digital mechanisms. So even when someone is sitting here, money can be in Singapore, moved to Brazil, back to South Africa. So even in terms of the way we conduct our evidence gathering, we also have to look at those elements. And what we're saying is you've got conventions that Zambia has ratified, and which gives us a platform in which we can engage with other nations to help in the facilitation of these things. You also have donor-driven programs and frameworks. For example, Zambia just joined the Open Government Partnership. This is an organization that involves government, business, and civil society, where we basically say, as the government, we expect you to do more. Yes, this is the minimum standard, but you can do more. And there's a lot of financial motivation or reputational consideration that actually encourage positive reforms, because generally governments want to be seen in the good light. So those are mechanisms in terms when we're looking at the policy, the legal reform. These are the minimum standards. These are the standards that can get us where we want to be as a country in terms of fighting corruption. So in concluding, it is essential to recognize the central role of human and institutional elements in the fight against corruption, as emerging technologies and preventive measures are not a silver bullet. With technology, junk in, junk out. So the element of a human being cannot be underestimated. And this is why we are saying, as human beings, we must act with integrity, because we are the starting point of everything. Anti-corruption actors should employ advanced advocacy strategies in protecting public resources from abuse and corrupt practices, and in building integrity in public life, politics, and businesses. It all goes to the culture of integrity. These include promoting legal and policy reforms, enhancing transparency and accountability in the implementation of government programs and policies, and in monitoring corruption trends, among others. Without a clear measure of progress, such as the Corruption Perception Index, it would be impossible to determine that we are actually winning the fight against corruption. So with those concluding remarks, I think for the prosecutors, the utilization of digital platform, management of digital evidence, witnesses that I'm sure you've had experiences where witnesses just don't want to show up when you come to court because of intimidation or some other factor. So how can you use technology to still have this witness be present in court? Because now we've got the rules that are advancing in our own high court, the utilization of digital platforms. But of course, you must remember there are also risks. There are risks involved, and those risks, as we advance in the utilization of technology, the risks also are going higher. So we must be able to reach a balance where we are cognizant of the fact and we manage those risks. Thank you so much.
Thank you for that presentation. If there are any questions, we can have a plenary session now. As you are giving your questions, kindly indicate the institution where you're coming from, your position, and to whom your question is directed to.
Good afternoon. My name is Zanji Sinkala. I'm the Communications Officer, Transparency International Zambia. My question goes to, is laughing. My question goes to ACC. In your submission, you talked about covert investigations. We just wanted to find out how long is too long for investigative findings to be reviewed. So, for instance, there have been different scenarios. I'll give an example. Maybe the Solicitor General, that investigation has been ongoing. So it would be good to understand. Of course, you need time, but how long is too long for those findings to be reviewed? Thank you.
We'll take 3 questions.
Good afternoon. My name is Milambo Sinyangwe. I'm a state advocate from the National Prosecution Authority. Hello? Okay. My question is to both the presenters. Firstly, with regards to TIZ, what role can society and the media play in holding power accountable and promoting transparency? Would it be, for instance, with regards to investigative journalism? And what impact would that have with regards to covert investigations conducted by ACC, for instance? Thank you.
Any other questions?
Mr. Kambia, Donald D, Senior Public Prosecutor from Livingston. Yeah, my question goes to the SEC. I don't know how you do with these pastors in churches, those who say, sow the seed, sow the seed. Is it not corruption also? Or is it just okay? Because pastors should preach against corruption, but they're the ones who are promoting it. I don't know how you can look into that. Thank you.
Thank you. Actually, respond to your question.
Hello? Is it audible? It's okay now? Okay. How long is too long? So the answer is that it depends on the nature of a case that is being investigated. Because there are times you receive a complaint against one person, and as you are investigating that one person, other doors open, which makes even a case to be longer than necessary. So the range of an investigation will depend on the complexity of an investigation that is being done. No wonder I said covered, because the moment you go to the public, you want to know the finding. You are interested. And if you come back and tell you that you've not found anything, you may not believe that. But one thing we should know, that when an investigation is being done, you are either verifying or establishing what has been alleged. So sometimes it can be a false allegation. Sometimes it turns out to be true, and you see us to going to court. So now coming to the role of the media and society. I'm glad that Mr. Sinyango, you answered your own question, sir. Investigative journalism. That is the role of the media can do, as well as our civil society cooperating partners. Because some cases that have been investigated and prosecuted have been as a result of a newspaper article, or even on social media. When you're posting your life occurrences on Facebook to show the world that you're happening, that information from the media has been used to check. Let's say Mr. Sinyango is always posting, it's by the post, it's by Avani. From their interest is developed to look into that life, and without you knowing that it was through media that law enforcement will come after you. So media is a tool that has been used. And when we say media, we're not just talking about newspapers. We're talking about the WhatsApp statuses, the Facebook posting, LinkedIn, even what is this other one? Instagram. So be careful what you post on those social medias. You might be opening a Pandora box for yourself. So investigative journalism, that is the answer. And we've used that in several instances. And lastly, Mr. Kambia, pastors in churches, is it corruption when they ask you to sow a seed? Or when you're being asked to give an offering? Is it corruption? I thought you were going to link it to money laundering and say they might be using that to launder the funds. Because imagine a pastor calls for sow a seed, and I know that I've got dirty money. I can just have an agreement with that pastor, give the money as a seed into that church, and the church will record it as I said that was sowed, and money would have been peacefully laundered. So there, our concern would be to worry about the possible money laundering that might be happening through these churches. For corruption there, we may have a challenge proving the corrupt elements. Remember, for every offense that you have, the enabling section will give you the provisions or the elements that you need to establish. And as the EFCC that we have now, they'll even tell you for a conviction to be secured, you need to prove each and every element of the offense. So there we may have a few challenges in proving the element. And the next question will be the complainant there. If someone goes, no, it was a seed I sowed and God answered my prayer. It was not corruption. What becomes of your case? Thank you.
I think just to add on what my colleague has said, I think it's important that even when COVID investigations are being undertaken, there's a certain level of accountability from the appropriate institution. I think as organizations, why we demand for transparency and accountability is to lessen the risk of interference. We are cognizant of the fact that there are sometimes underhand currents, especially when it involves politically exposed people. It's normal. It's something that we have seen. It's something that we have witnessed. So there must always be that balance between the convent investigation and the ability to ensure that even if you're not being transparent, you are being accountable enough as an institution. And that's what we always ask for.
Thank you. We've come to the end of our session. Join me in thanking the speakers of this session with a round of applause, and thank you also for your engagement. The program continues. There's another session that is taking place here, and at the same time, there are other sessions going on in the other rooms.
Good afternoon, everyone. My name's Tinta Chimbwali, public prosecutor from Southern Province, Livingstone. I'm the moderator for session 2A. And the topic is new approaches in the detection, investigation, and prosecution of financial crimes. On the 22nd day of July, 2025, the DPP declared war on financial crime. The public prosecutions has come up with guidelines to aid prosecutors in the prosecution of economic and financial crimes. The institution has also established the Taxation and Financial Crimes Unit, and also the investigation of financial crimes is essential for detecting and preventing illegal financial activities that erode trust and destabilizes the economy. The Speaker will eliminate the critical investigation processes, the sophisticated tools and techniques employed by experts in the field, and the far-reaching effects of financial crimes. Allow me to introduce to you the speakers of this topic for this session. Our first speaker is Mr. Mkelewai Kwalea. Mr. Mkelewai is the director in charge of the Anti-Money Laundering Investigations Unit of the Drug Enforcement Commission in Zambia. A lawyer by profession with 10 years experience in financial crimes investigations, 9 years experience in prosecuting financial crimes, and 3 years experience as head of the financial crimes investigators, the current position being held, and the contact point person of the Asset Recovery Interagency Network of Southern Africa in Zambia. Kindly give a clap for Mr. Mkelewai. Our second speaker is Mr. Hassan Sichone. He is an experienced prosecutor with a comprehensive background in criminal law and courtroom procedures, which span over 10 years currently. He is a senior public prosecutor at the National Prosecutions Authority in Lusaka Province and serves as part of the Secretariat team for the inaugural interagency and cooperation framework in Zambia. He holds a Bachelor of Laws degree from the Zambia Open University and an advanced diploma in business administration and management studies from the Association of Business Managers and Administrators, United Kingdom. He is an internationally certified trainer in financial investigations and asset recovery by the International Center of Asset Recovery, and also trained in international cooperation and mutual legal assistance in criminal matters by the Best Institute of Governance Switzerland. Kindly give a clap for Mr. Hastings Sichone. I'll call upon my first presenter, Mr. Mkelewai. He has 25 minutes.
Thank you, Madam Moderator. Like I've already been introduced, Kwalela Mkelawai is my name. Others call me the national asset. Obviously, you know better, you people from NPA. Been called to present a topic entitled The New Approaches in the Detection and Investigation of Financial Crimes. So as I navigate the gadget, you, Madam Moderator, you tell me where I should point my gadget so that I move to the next. So, I've managed. Okay, yeah, managed. So the presentation outline is as given there. I will briefly speak about financial investigations, the new approaches the new approaches in the detection of financial crimes. I will give the financial investigation plan, and I'll also speak to the subject profiling as well as the financial profiling of the subjects. So now the issue is what exactly do we mean when we talk about financial investigation? Firstly, we need to understand what an investigation is. Obviously, an investigation is obviously proving or disproving the allegation as presented. Now, I'll be cruising through because I'm mindful of the fact that I only have 25 minutes in which to navigate the 14 slides. So when you speak about financial investigations, we are talking about inquiring into the financial affairs related to a criminal conduct. The idea is to obviously identify, gather evidence which is necessary for prosecuting, which is associated or related to the subject. Okay, so the main task in the asset recovery investigations or financial investigations to basically aimed at gathering enough evidence which is expected to link the evidence to the subjects of investigations. So basically the investigator is expected to identify, follow the money, and link the money to the offense, the location of the assets as established during the investigation. So now this investigation is expected to, an investigator is expected to trace the assets, you engage into a variety of investigative techniques, including financial data analysis, which results in secure and reliable admissible evidence in the courts of law. So now an investigator should be able to determine what is the best technique on a case-to-case basis, depending on the report that is available at any given time. So now, how do we really get into this detection of the financial crimes? Okay, so begin with, there are several ways in which the Drug Enforcement Commission receives information. So information can be received on an individual, can be received on companies and other business entities, and therefore what is received at any given time by the commission is expected to be analyzed. So one of the sources of this information is from the financial institutions, Financial Intelligence Center, and therefore most of the information received is triggered by the red flags, which can be categorized in so many ways. You will find most of the information put in the category of unusual transaction patterns, of which includes some unexpected spikes or drop in the transaction volumes, and an unusual surge in transactions within the short time frame and frequency of transactions. You also find that this information, the red flags, can be obtained from the activities of accounts, where you find there's some sudden changes in the account activities. Now, such red flags mostly unsuspecting criminals would not know what we are looking for. If, for example, your account is known as a buffer which just receives a salary at the end of the month, and then suddenly you find that there is a credit of 2 million or 1.5 million in your account, which is only used to receive a 15,000 kwacha. That is picked as a red flag, as a way of how criminality can be, or fraud can be detected. If it's big companies, you'll be able to see the discrepancies in the financial records, the failure to properly maintain the balance sheet with so many inconsistencies in the entries. It's able to trigger red flags of the financial crimes or financial fraud in this regard. So now, to deal with these financial investigations, what is expected of a law enforcement agency or the Drug Enforcement Commission's anti-money laundering investigations. We, just like the criminals sit to plan, we equally do a lot of planning, and you develop what you call a financial investigations plan that should be able to give you what steps you need to take. So once you receive a report, in order to properly identify or detect the new approach that you need to do is basically get to know what exactly is the allegation and what are the possible offenses. Now remember, if you receive a report and basically you don't even understand what exactly is sitting before you, it's as good as heading to a destination that you do not even know. You will not even know whether you have arrived or not. So usually when reports are received, you read through and get to understand what are the possible offenses here. When did it happen? This also helps to know whether the investigation is already statute barred. There are times when you know ourselves that for financial records in the banks, you can only get as back as 10 years in the past to ensure that the financial records are still available. So it helps you to guide your inquiry, your investigation. So you get to know, when did this happen? Why did it happen? Who is involved? This helps you to get to detect who are your suspects that you are looking at in your investigation and how much is involved. So now these key questions will be able to drive the investigation to the project objective to ensure that you do a good job in the investigation. So now, as law enforcement agencies, it's always imperative that you detect these financial crimes early, whilst the evidence is still out there, still available. So, and therefore, you need to put up a proper approach to these investigations. So what we usually do, or what happens is, you, as a unit, we always have a dedicated and a designated team of officers which gathers the intelligence. Then we also try to enhance the business relationship within these several institutions where we recruit contact persons that we deal with in most of our investigations. So we are always expected to have a lot of contact point persons to be easily providing information to us. Should have contact point persons within NPA. I'm not saying I'm planning to recruit you or I've recruited you already. But some of you know how we have best worked together. But of course, that is only related to prosecutor-led investigations, not that you are recruited as the contact point persons to provide information. You also usually have the competent team of financial and the forensic analysts equipped with the modern tools for purposes of analyzing. The financial investigators that we have, even when the unit was just started in 2003, it was a team of lawyers, a team of accountants, bankers who were brought together to be able to analyze, because financial investigations may be complicated or are complicated, as you may be aware. So it's always expected that we have a committed and competent team of forensic analysts who are always equipped with the modern tools. So, and then the approach continues by ensuring that financial profiling of identified subjects under the undercover is done, and then after that we immediately come up with an inquiry file, which is disseminated to investigators. Once you know that you have strong evidence available to commence the financial investigation. So the second step, we move to begin, once you know that the matter has now been disseminated, so the approach is always aimed at ensuring that you collect records, basic information related to the suspect. This information, always, most of the times, the approach requires that you have to you need to have the correct name of the suspect, including other given names which may not be official, the date, place of birth, the passport, or the identity documents associated with the suspect. You also, the approach requires that you gather information that is associated with the people who are close to the suspect, the wife, the relative, the brothers, the sisters, including girlfriends. We get to ensuring that because money laundering is all about distancing or hiding the proceeds of crime. So you get even relevant information such as mobile numbers, the recent photographs of targets and associates, even open sources like we got from a colleague from ACC, open source information is gathered. You also gather information from government agencies, from the salary statement, if applicable, the real estate records. So when you identify also banks or bank accounts, other entities that may hold business records for the subject. So when we get now to the actual financial profiling, once targets are identified and profiles established, what is needed? An investigator will need to obtain information and the financial data, depending on the plan that is available. This will include assets, liabilities, the income, the expenses of the target, their businesses, and then the documents and other leads need to be gathered. When you put them together, this range of source of information, including the internet, other public available sources, most of this information will be able to be gathered from different sources as listed. The government agencies, for example, financial institutions, money safes, MNOs, for example, the companies, service providers, various registries, in short, real estates, insurance companies, even business competitors. We've come to establish that most of the times, especially when you are investigating big companies, you find that the business competitors have very valuable information against the other competitors. So all such are sources of information that we employ in the new approaches to financial investigations. So I'm told my time is up, but I think I'll just be able to show you that those are our partners, and so that the operating partners that we work with as we run with our investigations, and also just quickly telling you that after everything is gathered, the analysis of financial records should be able to give us the direction in the investigation. And then also just to emphasize that financial investigations are so complicated such that we always adopt the multi-skilled and multi-sectoral approach, depending on the complexity, and mostly cooperating with the partners such as law enforcement agencies as well as the NPA as we do the investigations. So also just to state that currently the money laundering prevailing trends in Zambia, the ones which have given us quite a good run for our money, they involve gold scams, money secretion scams. Most of you from NPA have been able to know so many money secretion scams cases that we have done in the past. Ikulile, Zisungile, Comsave, so many of them. And then including Kamono, we continue fighting, but the problem continues. Cyber crimes, the use of front and shell companies, suspected money laundering activities, cash smuggling, procurement fraud. Those are some of the issues that we run with at the moment. Thank you for giving me some extra minutes, Madam Timekeeper.
Okay, calling our second speaker, Mr. Hastings Sichone. Keep time, 15 minutes.
Thank you very much, Madam Moderator. All protocols observed. Good afternoon, ladies and gentlemen. My presentation will briefly touch the subject, the session topic, with the prosecutorial approach. And in that regard, we'll quickly just bring to your attention that under financial crimes, there are various types of crimes that are involved. And in that regard, we have fraud, we have tax evasion, we have cybercrime, we have terrorist financing, money laundering, and many other offenses. Now, with these crimes, you understand, you agree with me that this type of crimes in 1964 did not have the same circumstances or were not as advanced as they are in 2025. With the evolution of time, crime has also evolved, and the way in which it has equally evolved. That has proven some challenges with the way these crimes are prosecuted. So briefly, I'll highlight a few challenges that as prosecutors come across. First challenge is cooperation from persons or institutions who are involved in these crimes. You understand that you agree with me that anyone is capable of committing a crime, and in most cases, it's committed by syndicates in our societies, in our communities. But in the recent past, we've seen how people who are politically exposed or people in offices of power are actually also perpetuating such crimes. As prosecutors, when we receive these dockets, and you find out that in a particular statement, maybe the contract is missing that was mentioned, or maybe there's a relevant piece of information that should have been added to the docket is not there, you guide the investigator to go back to this institution or this person who sits in the office of power to access that information. You find that there will be challenges because that office or institution who understand that there's an investigation going on, and they will, in most cases, sometimes they tend to withhold that information. There's also the case of transparency in the investigation. The investigator only wants to be compromised, and because that affects the quality of the evidence gathered at the investigation stage. Also, the other challenge is prosecutorial competence. Of course, as prosecutors, we are capable of prosecuting cases, but cases vary. Are we competent as prosecutors to effectively prosecute financial crimes? Also, corruption is one of the challenges that has proven to be very prevalent in this complex world. You find that corruption and financial crimes most often involve huge sums of money, and those who are beneficiaries are willing to share a little of the percentage of the proceeds to investigators, prosecutors, magistrates, and judges. And also, the other challenge is the legislative framework. Is our legislative framework adequate enough or strong enough to combat the current financial crimes that are prevailing in our society? And the other challenge is jurisdictional challenges. As you have already heard, crimes have evolved and they are transnational. It is not especially financial crimes. It might start from Zambia, but it ends up in Japan. It leaves Japan, it goes to Australia. So there are other jurisdictional issues that are in effectively prosecuting financial crimes. Now, having faced or highlighted these challenges, what are some of the innovative strategies for prosecuting financial crimes? As prosecutors, we need to take advantage of the use of technology in court proceedings. And allow me to bring you to the attention of the use of virtual testimony. Under Order 3228 of the High Court Rules, it reads, the court may receive oral evidence from a source with and outside Zambia via audiovisual technology, and such evidence shall be recorded in the same manner as if the witness was physically present. This was effectively used in the case of Collins Sichula and another versus Perry, and it went up to the it was appealed against in the Court of Appeal, but the Court of Appeal upheld the conviction, the upheld the judgment of the lower court because of the rules that are applicable in the High Court. The other innovative strategy is digital evidence presentation. When we talk about digital evidence presentation, we are referring to emails, transaction records, cryptocurrency transactions, online activity logs, digital documents. And this digital evidence proves enhanced investigation, detailed insight into financial transactions, and it proves that digital evidence is more reliable than traditional paper-based records. And also, it can be obtained and analyzed in real time, and digital evidence can help follow the money trail, tracing transaction and identifying suspicious transactions. And this evidence can be admissible in court, providing a solid foundation for prosecution. The other point is collaboration with other agencies, also international cooperation. That has already been exhibited in our current investigation and prosecutorial techniques through the interagency, which Mr. Mukelebai has spoken about. We've got institutions such as ZRA, FIC, Zambia Police. And also, we need to adopt the use of expert witnesses. These include forensic accountants, cybersecurity, and cybersecurity specialists. Also, we need to explore settlement agreements. I think the most pronounced one in our jurisdiction is the one that was highly publicized, the Milingo case, in which the 24 million United States dollars was recovered. And also, we need to enhance the asset recovery mechanisms, which include non-conviction based and also criminal confiscation. What are the best practices for effective prosecution? The first one is building strong cases through investigations. As prosecutors, one of the guide investigators in their criminal prosecution. And in that regard, we need to give timely and effective guidance to investigators so that the case is not only thoroughly investigated, but also watertight. We need to collaborate and work closely with other agencies to share intelligence. And these agencies in our jurisdiction include ZRA, ACC, Immigration, DAC, and many other institutions. And also earlier in the morning, we heard about the Egmont Group and how FIC works with other institutions such as FATF in the fight against these financial crimes. We also need to utilize digital evidence, use expert testimony, and clear indictment. We need to clearly articulate the charges and allegations in the indictment, ensuring they are specific and well supported. And we need to effectively communicate with the judge and magistrates. With communication, we need to communicate complex financial concepts and evidence in a clear and concise manner. We need to prioritize asset, stay updated with emerging trends, and also international cooperation. As we have already heard, crimes are transnational, so you cannot overlook international cooperation. And we also need to increase capacity building of prosecutors. And this goes to investigators too. How do we balance innovation with due process and human rights with regard to financial crimes? With innovation, we need to leverage technology to enhance investigation and prosecution. We need to encourage collaboration between agencies and international cooperation. Regards to due process, we need to uphold the principles of fairness, impartiality, and the rule of law. And we also need to ensure that investigative techniques and methods comply with legal standards and respect for human individual rights. Furthermore, with regard to human rights, protect rights of suspects, defendants, and victims, including the right to a fair and protection against arbitrary detention. I should have put arbitrary detention in bold because that's one of the issues that are being looked at or being complained about by our various stakeholders. We also need to consider the impact of financial crimes on victims and communities and prioritize their rights and interests. In conclusion, as prosecutors, we need to embrace innovation and collaboration to combat financial crimes as our role keeps evolving in this complex world. And by striking a balance between innovation and due process and prioritizing human rights, we can effectively combat financial crimes while upholding the principles of justice and fairness. Allow me to leave you with this quote that I searched up from the internet. It states, criminals are not thinking in silos, and neither should you. And that marks the end of my presentation. Thank you very much.
Thank you very much. That was a very brief and precise presentation. Kindly give him a clap. Now we are going to take questions. We only have 5 minutes for questions. So questions, there is one, Mr. Tambia Donald. Another one. Okay, Miss, you as you put up your question, state the institution, your names, and which presenter the question is directed to.
Okay, my name stands the same, Mr. Kambia Donaji, Senior Public Prosecutor. My question goes to Mr. Mukelebai. Previously, there were some issues of missing exhibits. So now, what measures have you put across to ensure that they are not going to be missing exhibits when needed at court? Thank you, sir.
Who's asking?
Good afternoon. My name is Charles Peplan Mbewe. My question goes to Mr. Mukelabai. You've quite well explained how investigations are done and how a file of a case is compiled. Are there instances where you feel you've thoroughly investigated the matter and after submitting it to National Prosecutions Authority for further prosecution, the docket is turned back for some reasons indicated that probably there are other investigations that you need to compile or to follow? If they are, what have you done to ensure that the retained file, which you have thoroughly investigated, finds itself in court? Thank you.
Thank you so much. This is okay.
Yes, okay.
Thank you so much for those two questions. The first question was about the missing exhibits and what DCA has done to ensure that such occurrences do not persist. I think from my recollection, from what I'm able to recall, most of the instances that we've had of missing exhibits, you agree with me that missing exhibits, it's an instance which has been happening from the court side. And I know that at some point we even arrested some officials from the courts over missing exhibits, because court exhibits usually mostly miss from the side of the court after they have been produced in the courts of law. From the DEC side, I think it's very clear that even our rules of discipline, the issue of missing an exhibit is a very serious one. It's actually a dismissible offense. So it's very rare that such instances happen in DEC, or if you have a few examples, probably you could bring them forward, or we may not be aware about such, because it's a very serious disciplinable offense of missing an exhibit. If it is established, you are on your way out of the DEC. So that's what DEC has put in place to ensure that exhibits do not miss. Exhibits which have missed in the past have been on the other side after they have left the DEC. The second question was about dockets that are submitted to NPA. Of course, like I stated in my presentation, most of the times we do prosecutor-led or prosecutor-guided, depending on the terminology you want to use, investigations where we are working with prosecutors. And most of the times, immediately an investigation has reached an advanced stage. Personally, I've worked with a lot of prosecutors here, and most of the times when we submit the docket, we are usually 100% or about 95% sure that we have done a good job. But in instances where dockets are returned, we always try by all means to quickly run around and be able to attend to issues which have been pointed out by NPA, and we quickly attend to those and then resubmit. We are, as a unit, we are gauged by how many dockets which have been returned and resubmitted to NPA. So we are very serious on that one, and we always make sure that once it has been returned, the docket has been returned, we try to do as guided within the shortest possible time, and then dockets are resubmitted. And mostly that's what has been happening, and that's how we have worked very well with the National Prosecutions Authority. I thank you.
Okay, at this time, help me in thanking our presenters for their powerful presentation. Let's give them a hand of applause. Thank you so much. Up for the next session. Even for the moderator, give a hand of applause for the moderator.
Good afternoon. We are back. Um, we now have the last two sessions before we call it a day. So we are almost there. We still have some information to carry home with us. Without wasting much of your time, I'll call the next presenter. And after this presentation is done, we will be joined by other dignitaries that we identify but were not in the hall. I will pause so that we can recognize them and welcome them. But for now, we'll proceed with the presentation. I will call upon Madam Womba to come forth. She's signaling that she needs encouragement to come here. So please encourage her. Madam Womba's bio and credentials are on the screen. So she will proceed to render her presentation. Thank you.
Thank you very much. I'll ride on the protocols that have already been established so that we can catch up on time. I must give a big thank you to my colleagues in the NPA, especially the DPP and my colleagues in the Gender-Based Crimes Unit. So we'll proceed. My hope for this afternoon is to try and recruit as many of you as we can onto this type of work, which is not the best because sometimes it can be very depressing. But I hope you will see the greater good for a woman out there, for a girl out there, for a boy out there, and for a man out there. So I'll talk about harmful practices, and I'll talk about how we have evolved generally in Zambia, legally speaking. So I'll define harmful practices just in general, and then we'll move on to the issues of child marriage, which has been like one of the dominant harmful practices that we have been experiencing here in Zambia. So in as far as the theoretical definition is concerned, harmful practices, just in general, these are persistent practices and behaviors that are grounded on discrimination on the basis of sex, gender, age, and other grounds, as well as multiple or intersecting forms of discrimination and violence, and cause physical and or psychological harm and suffering. In the slides that follow, I think we'll be able to get more into the details of the effects of harmful practices in general. So globally, child marriage and female genital mutilation are dominant practices, but we know that there are so many others. Breast flattening, I think in Central Africa, Cameroon, and so on, and so many others, virginity testing and whatnot. You will see that some of them are actually cited in our law here in Zambia. So, in as far as child marriage as a harmful practice is concerned, this is any marriage where at least one of the parties is under the age of 18. I think those who've been on this road for a while do agree that we've had a lot of discussion around this age, but I think this is the general consensus, globally speaking, and that's what we've adopted as well in Zambia. So adolescent pregnancy is one of the offshoots that is related to harmful practices, and this is any female aged 10 to 19 years. And they are the ones who are in the bracket anyway of the child marriage confinement in terms of the age. And this is the demographic that is mostly affected by adolescent pregnancy or teenage pregnancy. So a child marriage is considered to be a form of forced marriage, given that one or both parties have not expressed full or free informed consent. We know generally for the way in which our penal code is structured, we have the issue of anyone below the age of 16. When a defilement case is presented as thus, consent is immaterial. So okay. So I wanted also to just mention quickly that because of discrimination, because of gender disparities, and because of gender inequities and inequalities, there are issues that we need to take into consideration when we are presented with such crimes as child marriage. Defilement is a whole different arrangement altogether, because I think the definition and the punitive measures are clearer. But for child marriage, you will see when we look at some of the statutes that we have, we do not have the commensurate way in which the punitive measures should be rendered. But I'm just bringing this slide to say, if we are gender blind, we risk asking the pertinent questions that will lead us to the correct manner in which such cases should be prosecuted. I know that on the back end, the investigators will really have something more that they should do before they come to you. But nonetheless, this is just a slide to say we really need to be conscious of the gender dimensions that are at play when child marriage presents itself. So these issues of the issue of being gender blind means it ignores the set of economic and social and political roles and rights and just the fundamental freedoms that men or women, that boys and girls would have. Then gender blindness also ignores the power dynamics between men and women, between boys and girls, between males and females. When we are gender aware, we are trying to move towards the ideal. So there, it's the basic minimum where we are examining and we are addressing these issues, these gender stereotypes, these confinements where we put a boy in that box and a girl in the other box. And there are things maybe that we know that are an entitlement for the boy, but not for the girl. So we are just coming to a bare minimum to recognize that that fact. Then when we are exploitative, we label, we disadvantage people on account of their gender. When we are accommodating, we are working around the existing gender differences, just trying to accommodate. Okay, let's say re-entry policy so that maybe more girls can come back to school if they fall pregnant and so on and so forth. Just trying to barely accommodate issues and the differences and inequalities. When we are transformative, that is now towards the ideal situation. We are looking at the gender norms, the dimensions. We are also looking at issues around strengthening and creating systems that support gender equality. So as we come to the end of my presentation, I'll say something about some proposals, because if we do not do something about harmful practices, we really risk losing a generation, because this is a situation that is very glaring and very stuck in our reality at the moment. So our hope and our goal is to really go towards gender equality and better development outcomes. So child marriage, again, we are just trying to say, because of issues of adolescent pregnancy, if we lose the 10 to 19 from the school system, or we lose the 10 to 14 or the 15 to 19 from the school system, it means the aspirations of being in tertiary education is diminished somewhat. So we are just trying to say, what more can we do? And because adolescent pregnancy is very related to child marriage, we are trying to say, how can we curtail this? Because in many of our contexts, especially in our rural parts of Zambia, when a girl presents herself as pregnant to parents or to guardians, the default position is to allow or to have that girl go through a marriage. So that's why we are trying to say, how can adolescent pregnancy be dealt with? Like I said earlier, this is a form of forced marriage. It's also a form of GBV. So that's our adolescent population. This was from the 2022 census, the earlier analysis. And we have over 5 million adolescents. That's the 10 to 19, male and female, are demarcated there. This is 2018 DHS. We are still hoping that the 2022 DHS analysis will soon be ready, but the physical violence, just the assault and all that was standing at 36%. 36.6. Sexual violence, this is where we have the rape, the defilement, 14.8. And then emotional violence or emotional abuse, 31%, as it were. Child marriage, this is, to the best of my knowledge, the latest figure is at 29%. And the way DHS calculates is for ever married, 20 to 24, got married before the age of 18. Adolescent pregnancy for the moment is 28%. So in essence, if we're just to look at it roughly, out of every 1 out of every 3 girls is pregnant. So at the end of the day, we really, really need to do something about this. Thank you. I wanted us to look at this slide. This is the analysis. The darker shades are where child marriage is most prevalent, and we are seeing in the North region, Luapula, and parts of Eastern Province. And as we go down, we have a darker shade as well in Southern Province, lighter shade in the West. The West is a bit unique. I think over the past 2 years or so, the data might be different, but adolescent pregnancy is very glaring. When you are in Sioma, when you are in Changombo, when you are in, I don't know, Mitete, any of those Western districts, almost every teenager you see is pregnant. So we really need to do something about it. So we are talking about ending child marriage. We are talking about looking at adolescent pregnancy. We are saying, how can we build a critical mass of men and women who contribute to national development? So if we lose these girls and they are not completing tertiary education, that is a risk already. So what are the issues? In order for us to create and to build a critical mass of men and women, boys and girls who can contribute effectively to the nation, we really need to curtail and put a stop to these issues of harmful practices, and more so to put an end to child marriage. So some of those effects, adolescent pregnancy is one, obstetric fistula is another, because obstetric fistula does exclude them even from the marketplace, exclude them from churches, exclude them from everywhere because of the type of condition that it is. Meaning that someone is passing urine on a regular basis because of protracted labor, the bladder gets punctured. So that is what obstetric fistula is. And it also excludes the girls from public life. Morbidity, in extreme cases, it's mortality. On another hand, when you look at the social aspects, definitely there's the loss of dignity, school dropouts. By and large, many researchers who have done some work around this issue in Zambia of school dropouts say that more than 50% do not return to school after they have had a baby. And we know that usually the burden of childcare would rest with the adolescent girl. So definitely this is something we need to look at. Limited opportunities for adolescent girls and young women. The famous grade 12 clause, we are in a pre-election year. If the girls are lost and they are not completing grade 12, how do they then compete with men even in political circles? So that's where we are. I won't go into much detail of the legal frameworks. I'll just make mention. I know that I am preaching to the converted, as it were, but my hope is that some of us will want to make a switch from the, I don't know what word I can use, maybe nice prosecutorial work in terms of maybe, let's say, corruption or financial crimes, and look at this issue of gender-based violence and harmful practices. But in essence, since 2011, we've had this definitive legislation. It does acknowledge harmful practices. It does acknowledge issues of forced virginity testing, female genital mutilation, pledging of a person, forced marriage, sexual cleansing, and so on. But we still need to move forward. What more do we do to rid our communities of such vices? Along the way, this is now more than 10 years along the way, 2022, we have the Children's Code Act. In the Children's Code Act, child marriage and indeed FGM are prohibited by law. At least that is the wording used. We move forward again, 2023, the Marriage Amendment Act. And I know that the amendment was just looking at Section 33 and looking at the issue of the age. It's also clear. But I know that there's a bit of an issue, that how do we ensure that these cases come from the police to yourselves, and how can we build case law at least around arresting perpetrators of child marriage? So as I'm about to conclude, in Kaoma, we heard of a case where a 17-year-old has been married in this year, 2025. And this case was presented to the Inspector General of Police by way of the mother of this girl writing to the Inspector General of Police that she was seeking redress and she wanted the perpetrator arrested. So anyway, along the way, when the police in Mongo tried to intervene and try to get to Naoma, what the girl said is that she herself was in the marriage and she wanted to remain in the marriage. And upon further investigation, it was stated that her mother had actually been given 10 heads of cattle. So when the police tried to interrogate her to say, you wrote this letter on the basis that you really wanted this matter dealt with. And then she claimed that she was not fully informed by some relatives who were supposed to have received the cattle, that the cattle had actually been moved from the same man who had married her daughter to their, I think I can say, their family farm. And as fate would have it, this man, this is the third girl I can say. He's marrying. He already has 2 wives. So this girl actually left school. She was in grade 12 and she has insisted she doesn't want to go back to school. So these are just, sporadic cases that we may hear of. But when you are out there in the community, you will see more of them that this is the situation. So what are our proposed actions? I will speak from the social point of view, from a programming point of view, but my hope is that some of you may be encouraged and enticed more into doing a lot more research, a lot more work in this area around support to girls and boys, around support to men and women, around support in gender-based crimes in general, but also looking at child marriage in particular. So we need more engagement at community level. I know that it will not be the easiest road to navigate, but I think there are ways and means in which, at least at the barest means, you can get to know and to see firsthand what's happening at community level. So innovation on how to prevent harmful practices. Then the gender lens and innovation in prosecution. If we do not have the gender lens, we will continue to insist on things which we know might not be very practical. But if we have the gender lens, our thinking will be broad enough to say, what else can we bring as evidence? What else can we do? What else can we ask in terms of being able to have a solid case, as it were? Supporting the operations of the one-stop centers across the country. I'm just saying at least 4 visits. I should have actually said at least 4 visits in a year, not in a month. I know it won't be practical, but if we can try, because then you will know. It should have been late last year or so. There was a newspaper article that we had so many adolescent pregnancy cases in Northwestern Province, just one province. But I think from Madam Hambai's words, when she asked the NPA office, the defilement cases were very few. And these were cases maybe prime gravida even as low as 10-year-olds, 12-year-olds. So where are these cases being reported? If they are being reported at the police, why are they not coming to ourselves as NPA? So anyway, how do we support the one-stop centers or the police stations and so on? Personally, I'm a firm believer in CCCI. And I hope we can continue as NPA. DPP made mention in the morning and a few others. We can continue in these platforms and many other platforms. Continuous personal and professional development. I think this has been stated earlier. When I wrote this, I was thinking that with the internet, with AI, with a lot of information, I think we can do more personally to make a switch towards looking specifically at issues around gender-based crimes. Full implementation of the rules and the laws on ending GBV. I think one landmark is the ZP Form 32. Of course, it might not be perfect, but I think it is a lot better than what we had in the yesteryear. How can we move with the current legislation, and what more can we do to make sure full implementation is attained? I think DPP mentioned that we are public servants and we should do the best that we can because we are serving the people out there. Support to police. We've talked a lot about prosecutor-led investigations. How can we do more of this? I think the more we interact with our colleagues from the police side, with our colleagues even from crime prevention side at community level, it will not be perfect all the time, but at least I think it will give us an idea of some of the pitfalls and the flaws so that we at least mitigate some of the the concerns and the challenges before it's too late. So we just want to show that as UNFPA, we are with you on this road, on looking at gender-based crimes, on looking at harmful practices. My colleague will present something tomorrow specifically on technology facilitated GBV, which is a whole big thesis altogether. And unfortunately, it's evolving very quickly, even here in our context in sub-Saharan Africa. But what we are saying is that how can we work together in ensuring rights and choices for all? And so that picture is just some of the work we are trying to do with boys, trying to see how can they unlearn some of these harmful practices or bad vices, so to speak, and how can they look at girls as partners in development. So that is where we are. I'll end here for now.
While as Madam Womba is still here, any question? Bob?
Good afternoon.
This one, I recently learned of a
Any
concept
question?
called
Bob?
obstetric violence. Yeah, and I was just in relation to the
afternoon.
adolescents that are pregnant. Have you had information that they are suffering this type of violence from
I
midwives
recently learned
and
of a
nurses
concept
going for
called
obstetric violence? From what I learned,
Yeah,
is
and I was just
mistreatment of
in relation to the adolescents
pregnant women
that are pregnant.
and usually the
Have you
younger
had
women get the brunt of
information
that they are
mistreatment
suffering this type of
by the
violence
professionals?
from
And
midwives
if so,
and
is
nurses
it then having
going for
that
obstetric
to work
violence. From
with
what
the
I learned,
NPA
is
together with
mistreatment
more
of
subsidizing
pregnant women
the
and
medical
usually the
professionals?
younger women get the brunt of that they are
Mistreatment
suffering this type of
by the
Would you want to
violence
professionals.
from
come in on
And
that one?
midwives
if so,
and
I'm
nurses
is it then
sorry, I have
having
an
that
advantage because my
violence
boss is here.
from what
with the
I learned,
NPA
But that's a
together
big
with
area,
more
yes, and we've seen it.
subsidizing pregnant women
Maybe let me
and
allow him
usually the
to
younger
say
women
something, then I'll come in on the
the
last.
brunt of that they are suffering this type
Thank
of
you.
Would you want
violence
to
from
come
Just
in on that
two
one?
midwives
two immediate
I'm sorry,
responses
I
come
have
to
an
mind.
advantage because my boss is here.
In
from what I
general,
learned,
But that's
the
a
focus
big
of our
area,
work
yes, and
with
we've seen
midwives
it.
or other
Maybe let me
medical
allow him
professionals
to
that
say
work with
something, then I'll come in on the last.
pregnant women in
thank you.
general, particularly adolescent girls, is quality of care, and it comes with the right attitude. Um, Specifically those that are at the age group of, we say 15 to 19, but we have many cases that are below the age of 15 that come to health service, they come for health services. And then what you at least expect in that situation, if you can imagine you're a 14-year-old girl and you're indeed treated not with the dignity and respect that you hope for in an health service. Two immediate responses. I must say, at least expect in that situation. Of course, these are rare, 14-year-old girl, and well, maybe not rare, but not with the dignity and respect that you hope for in what we see. What is important in addressing is immediate response stage. And therefore, we are aiming at parts of judiciary, parts of the police, part of medical response teams, as well as the counseling and social services, to actually work together to provide the adequate support. And if there is a mistreatment in any of the broader service package, it can be easily picked up by the one, for instance, by the victim support unit or by the psychosocial counseling that should be part of the package. I think that is the most, that would be my response, Womba.
Yes, thank you. So I think what the rep has mentioned, especially on attitude, it's been a problem, but I think it's slowly, people are waking up to the reality that young people are having sex. We don't like it. Even I myself, I don't think I even want to mention that, but it's the unfortunate reality in which we are. Thank you. The other side is that
I think what the
the
representation, especially
unfortunate
of
part of it is also that it's been a adolescents are being abused. Some are being abused in our homes. I think maybe 3-4 days ago, we had a conversation with Mrs. Ambaya about incest. The other side is that so much of incest being unfortunate part of it is also that and you would imagine that you are maybe 12 and you are pregnant and it's your father. Maybe 3-4 days ago, we had a conversation. These are cases we are seeing more of. The other side is that now coming to the midwives and the nurses in general, there's been a big package, as has been stated, help them have a better approach and a better attitude. But the bigger elephant we are grappling with is the moral dilemma. In most cases, the other week I was in Western Province. I was specifically in Sesheke. And I was made aware of incest being a crime gravida of, I think, like 12. If you look at that girl, she probably even looks 10. In most she's heavily pregnant. And the photos were sent to me. And I was asking, is the person who's made her pregnant known? And they said the community is aware of this person. And I asked where he was. I was told he had crossed over into Namibia. So already in my mind, I was thinking, okay, this is a real perpetrator. And I was asking, is the but what the medical practitioners and they said the community is for transportation. This girl was like 126 kilometers away from Secheke. So already in my mind, I was thinking, and that takes maybe 5 hours. And I was asking on a good vehicle by road. And they are saying we can't allow her even to have a baby in the health facility. She has to come to a parent facility or to the hospital so that we try and do a C-section, just so that we don't lose this child. So more and more, some medical practitioners are alive to the fact that sometimes or many times it's not their fault. So we have like two moral issues to deal with. That's why in my mind as a programmer, I'm really thinking, who else do we need to talk to deal with prevention? Prevention of these issues of child marriage and adolescent pregnancy. But yes, the reality out there is quite real because we do have some conservative health workers who still want to, slap a girl. How did you get yourself pregnant? Without even finding out that maybe she was even defiled or raped for that matter.
Thank you very much.
How did you get yourself pregnant?
For highlighting the harmful practices.
Finding out that maybe she
We
was
need to
even
stop them.
defiled or raped.
As
for
you
that
can
matter.
see, the silence in the auditorium means the message needs to be clear, because there's a huge problem that needs to. Thank you very much.
How did you get yourself
Almost say
pregnant?
the
Without
highlighting the
even
harmful
finding
practices.
out that maybe
Thank
she
you,
was
thank
even
you, thank you.
defiled or raped.
As
for
you
that
can
matter.
see, the silence in the next presenter is already here. She's Margaret Chitundu. She will present on assets recovery, and we'll have her exhibit what she's been doing and the department. The bio is on the screen, and I'll allow Mrs. Chitundu to take it away.
All right, thank you very much. Good afternoon, everyone. No. Good afternoon. I know we are tired, but let's give it some energy. We're almost going. So, good afternoon, everyone. Yes, that's more like it. I know we've been listening to such gloom. It's such a heavy topic to hear about these kids getting pregnant from incest and all that. But yeah, unfortunate. So we'll talk about asset recovery as they are beaming my presentation. My good prosecutors and investigators, I would want to assure you that when I look at those beautiful cars you park, your expensive watches, your big businesses you're doing, that I don't think about where are they getting the money. But if I said I don't think about it, I would be lamentably be lying. So I will not say that. So we will talk about asset recovery and taking the profit out of crime. That's the so the dirty hand must not profit. That is one of the tenets of asset forfeiture. Unless you're a farmer, you must not profit from crime. So why do people commit crime? That is the biggest question. Other than the crimes we've had, these crimes of incest, defilement, what is the really big reason why people commit crime? Since we don't have time, I will not give time to people to respond to that. How many people have watched that movie, Griselda? How many have watched it? If you haven't watched it, please find time to watch and you will see to what lengths people go to earn money and to conceal it and to ensure that they keep it. It's a good movie to show us what really happens out there. But the real reason why people commit offenses is that money does really make the world go round and it's all about the money. Traditionally, the way we were dealing with crime is that we were dealing with it from the branches. We were not dealing with crime from the roots. So the traditional way, the way we knew it is we would just cut the trees, the branches, but not go to the root. Because at the root of it is the money. When people commit offenses, they want to keep the money. But you would find that would prosecute well, give them long jail sentences. They would go and serve the long jail sentences, but they would still keep the money. So we were not really effectively fighting crime. And what you'd find is that someone will commit crime through a drug offense, but they'll use that same money to do human trafficking. They'll use the same money to finance terrorism. So it's the same money which now is used for other offenses, and then crime thrives. So the best way to deal with crime is to cut it from the roots. And how do you do this? This was just how the traditional methods of fighting crime were not working. I'll not delve into it because of time. And this is also a picture which is talking about how people do not care about the long jail sentences. I can commit an offense, go and serve the jail sentence, but as long as I keep the money, I'm good. So then the nations realized that there was something wrong. Despite the long sentences, despite the big crimes, the jail sentences and the big offenses which were being given, people were still committing crimes. It was still thriving. Came in the Vienna Conventions, the FATF and other instruments, which I'll not go into detail. So that is just the history behind it, which I don't have time to go into it, how we got to where we are today, and also the advantages of asset forfeiture. Unfortunately, I will not have the time to go into detail, but we will share the presentation. You could have time to go through it in your spare time. And so this is the legal fiction. This is really what this is about, because in the non-conviction based forfeiture, we believe that it is a property which has committed the offense. So that is really what the non-conviction property is. I will not go into the protecting third-party interest due to time. I'll also not go about to talk about the lifting the corporate veil due to the time constraints, but we'll talk about the achievements and how we got to there. So we've had three big game changers, among others, and one of them is our president. So one of the things which have helped the asset recovery fight is when he came, he was very big about financial investigations and prosecuting them effectively, and also asset recovery. So one of the things why we hear about all these good things which we're hearing today is because we have political will. So everything rises and falls on leadership. We have good leadership ensuring that the asset recovery fight is being fought. We also have the DPP, who is really, really big on asset recovery and financial crimes, other crimes as well, but he really, really champions the fight. We also have the Chief Justice, who helped create the Economic Crimes Court, which His Lordship talked about this morning. And I'm not saying this because he's here, but everyone who hears me talk about the Economic Crimes Court knows how I praise them. They're just This court, which is very innovative, let's talk about innovation. The Economic Crimes Court is there. They keep us on our toes. They keep us doing the right thing. They keep us reading. They keep us burning the midnight oil when we go. So the Economic Crimes Court is really, really doing a fantastic job. The jurisprudence they do is really, really reasoned, well thought through. When you get it and you share with other jurisdictions, we're really doing well in that aspect. The other game changer is interagency framework. If you want to go fast, go alone. But if you want to go far, go with others. And that is what we've realized. We're really big on teamwork because we realize you can't fight crime alone. No matter how brilliant an institution you are, you cannot fight crime alone. So we have the interagency framework. Also, one of the brainchilds of the president, he gave a directive to the institutions not to work in silos, but to work as a team. So we're doing really good things with all the 21 institutions under the framework. We've seen a lot of successes. I will not share the summary of what the Asset Forfeiture Department has done. We will share the statistics, but those are our statistics. We have forfeited over $28 million, 266, over 5 billion kwacha, and all those ones. So we will not go into those as well. But then the DPP is usually in the papers for some of the recoveries we've made. And so now we'll share some of the few cases which we have done so far. We forfeited $28 million from one of the former liquidators. This was a very, very interesting cases. It taught us many lessons, and we managed to forfeit that. We also forfeited 38 million kwacha in the Nigerian case, the FEMA Nigerian case. We also forfeited that house from one of the former first daughters. We also forfeited those flats. There were 9 fully furnished flats from the former first lady. Talk about this ranch. So this ranch is 615 hectares. I think it's land which many of us would safely settle and give each other 21. What are those plots we give? 21 by 5, 21 by 21 by 50. And I think we would we would well settle on that. But that property belonged to one person, and that was what was there. We successfully forfeited that. We also have a case, this is still in court, but we've taken over 68 motor vehicles, a fully running filling station, a 2-story building, shopping complex, and 21 real property. Now, this person, when we tell you what he was doing, you'd be amazed how they came to have that. We also managed to forfeit that lodge, that's Crest Lodge, and it belonged to Mr. Charles Peary. Then we managed to forfeit over $5.6 million. We almost forfeited that very luxurious plane. It was a very good plane, but we talked about third-party rights, and they came and they claimed, and it was shown that it really did belong to those third-party rights, and so we didn't. We only forfeited the 5.6 million and then the fake code. We also managed to forfeit that code worth $2.2 million and that beautiful vehicle. And we forfeited those 9 fully furnished flats in one of the areas in Lusaka. One of the things which asset forfeiture wants to do is to take the money from the wrong hands and give it back to the right hands. So if I steal $1 million as a public servant, people have trusted me and put me in public service to ensure that I give a service. But if from my service I steal, let's say $1 million, which I may never see in my life, but let's just be optimistic. If I steal $1 million, what should happen is if people now take that $1 million away, because I stole it from the people of Zambia, we should give it back to the people. it should be able to enrich the people of Zambia because that is who it was meant for in the first place, isn't it? So what we seek to do is that we'll take the property. If, for instance, I bought a lodge, we can turn the lodge into a safe house. If I'm a drug trafficker, and you find that I built a hotel from that, if you turn that house into a haven for all these people who are now calling, unfortunately, junkies, which I know is not a good term, you turn that into a rehabilitation centers for them. That is giving back to the economy, to the community. And that is what we seek to do. If someone was running a brothel or was running a sex trade or was trafficking women and then they were being sold as into sex as sex victims, if we turn something which you got from that sex person, that human trafficker, and you made it into a safe haven for women, you made it into a safe place for victims and women, that is really fighting crime and giving back to the community. So that is what we seek to do. So that house, it's a lodge. We're hoping that after appeal, it can be turned into a safe house for women and victims. We're also really big on the mukula now. We've learned that our mukula and our rosewood is one of the best in the world, and it's being really exploited. When it goes out to the countries I will not mention, it's really sold at a really, really high price. So we learned that if we don't do anything about it, our trees will become history. It will be something which will say, we used to have rosewood in this country, we used to have mukula. What we are now doing is we're not just getting the logs. When we find a truck, because the trucks are really quite expensive, when we find the truck, or if it's a factory, we will forfeit, we'll make an application for the trucks, for the factories as well, and for any instruments which were being used, because that way we're being more effective. We're not just taking the mukula, which they know that they'll still go and auction, because most of the time, when you get the mukula, they'll be auctioned, and you find that, I will not mention the nationality, but you find that these nationalities will be at those auctions and they will buy those trees. They would have auctioned them. They'll now have the papers. They'll put them back on the trucks and they'll cross the border. What have we done? We've actually given them, legalized it. So what we do, we take the vehicles, we take the factories and anything which is related to them, and we make the forfeiture applications. And so far, thanks to the Economic Crimes Court, we have had 44,000 mukulas forfeited, 44,000 plus mukulas forfeited to the state, and we still have some cases before the courts of law. So this is the case which made Mr. Mukula the national asset, and he likes boasting about it. When he started his presentation, he said how he's a national asset. So that's the case which he did. He did a fantastic job, and we managed to seize those helicopters from both South Africa and Zimbabwe. And they are here. This was a good case of interagency, international, and intra cooperation. Ponzi schemes, we've seen a rise in these cases. Now, there's a lot of adverts which go on, and there are a lot of Ponzi schemes, pyramid schemes going on. And most of us, you read, you have 100 kwacha, someone says invest 100 kwacha, and in 2 weeks you have 1,000 kwacha or 5,000 kwacha. And most of us would do that. But then if you stop and think, how does that work? How do I put in 100 kwacha today and in 2 weeks I get 5,000 kwacha? So like they say, if it's too good to be true, it probably is too good to be true. And most of these cases are moved by greed, because if you calculate properly, 100 kwacha will not give you 5,000 kwacha in 2 weeks, because how have they multiplied? So most people are brought in and they join these Ponzi schemes. We've had a lot of them. And the challenge is now sometimes we're wondering if the state is being used as just that vehicle which gets the Ponzi schemes. We make applications and we give the money to the victims. So we've been actively discussing in the interagency to say maybe even the victims should be treated as offenders, as a deterrent, because that is also one of the things. When you join this, it's an illegal activity. So that's one of the interesting things about these Ponzi schemes. We have quite a lot about them. Asset management, it is something which would take the whole day to talk about it. It's really not what it should be, very far from the ideal, but we're hoping that it will change very soon. And then those are the challenges which I'll not also go into. the way forward, and then just the way to go. Without cash, criminals cannot continue, so we must take the money. I'm waiting for our president to give such mubweza, but so far we don't have it, so we still use the Malawan one. Thank you very much for listening, and let's take the money from the wrong hands and bring it to the right side. Thank you very much.
Thank you very much, Mrs. Chitundu, for that highlights that you've given of what the asset recovery process is in Zambia. At this time, I would like to recognize the presence of our distinguished guests who had earlier on alluded to, but they're now in our midst. And we'll also request that they'll give a few remarks, just a few remarks. So in that vein, I wish to recognize the presence of Dr. Musa Adamu Aliyu, who is the chairman of the Independent Corrupt Practices and Other Related Offenses Commission of Nigeria. You're welcome. You're welcome. I'll proceed to recognize the DPP from Kenya. Then I'll ask the chairman to come and give you a few remarks, and the DPP equally. Ladies and gentlemen, we are about to close, and they are within time. As I sought your permission that you indulge me, isn't it? Excellent. We also have in our presence the Project Director of Public Prosecutions from Kenya, who is in our presence, and this is Mr. Ngonga. Thank you very much. We appreciate your being here. Chairman, you may come through, sir.
Thank you, MC. The Director of Public Prosecutions of Zambia and that of Kenya, my distinguished colleagues, good afternoon. I'm really glad to be here today in this important conference organized by the National Prosecution. And as chairman of ICPC, I am really impressed with what Zambia has been doing, because the DPP of Zambia and the Anti-Corruption Commission of Zambia are two key institutions that Nigeria will have always been looking at and work with. Like what I told the DPP today, that Zambia is the only country that when I approach them on how we can work together, they are always happily ready to come. And this is very good, because it has shown that Zambia is doing well. And also this will strengthen the United Nations Convention Against Corruption, African Union Convention on Combating and Prevention of Corruption. And we in Nigeria, we are really happy to see how we can work together with Zambia in the fight against corruption. And as chairman of Africa Asset Recovery Practitioners Forum, we are working closely to see how the asset of Africa, taken out of the shore of Africa, are traced, identified, repatriated back to Africa, and also to be used for our people. So I am really happy to be here, and I hope this will open a door for collaboration between Zambia and Nigeria in the fight against corruption, which is one of the major problems that Africa is facing. And tomorrow I'll make my presentation on asset recovery, and I'm happy that we are going to share our own experience here, and also even for the few minutes I stay here, I learned a lot from the last presenter. So thank you so much. I really appreciate it.
Thank you very much. We look forward to tomorrow's presentation. It's now my privilege and honor to call upon the DPP from Kenya to give a few remarks as well.
Thank you very much. The Director of Public Prosecutions for Zambia, my brother, Mr. Firi, Dr. Musa from Nigeria. Colleagues, participants, good afternoon. Yeah, it's my pleasure to be here, to be with you during this important conference by the National Prosecution Authority of Zambia, a conference that brings together all prosecutors within the country. And again, those invited from other jurisdictions for us to be able to share our experiences and the best way to do prosecution. I'm excited about the theme of the conference. In the ever-changing world, we have emerging trends, emerging crimes, which is a challenge to most of us as prosecutors. Criminals are always ahead of us, and in most cases, we try to do catch up. The best thing for us is for us to be innovative in most of the crimes that are committed. Some of the crimes you find that have been committed, we don't have laws that deal with those crimes, but as prosecutors, we must find a way of prosecuting those criminals. We must be innovative and be able to use our laws and make them work for us in the best way we can. In the cyber world, criminals are always using that space to target and suspecting either members of the society or even governments for them to be able to commit crimes and get away with it, mostly because our laws are inept insofar as prosecuting those crimes are. But with prosecutors who are innovative, I believe we can do it. We have done it before and we do it. I look forward to an engaging conference and be able to come out with something out of this place. Thank you very much.
Thank you very much indeed. We have now come to that time when we will have to bid farewell to one another and meet again tomorrow at 08 hours for another, again, insightful day of this 3-day conference that we're having. So ladies and gentlemen, for today, this is where our journey ends. We'll meet tomorrow at 8 hours. Thank you. Oh, but we shouldn't just part away. There's some tea that has been prepared in the foyer, everywhere else outside and in the VIP lounge. After that, that's when we can part one from the other. Thank you.
Nobody contandiza kunchosa mabu. Nobody pensebe somunilege ngapego angoncha unizire ngapego angoncha. So, God, save it when I think it down. Don't know the just not. One feet I right. And I need me chasing my when my joke, need me so each other. And I need me chasing my when I be just need me so each other. Oh, my God. Shake it. Get back to the God. Oh, God. When I saw learn power, confident, you know, sleep when I think there, don't have to learn. Confident, right? Nothing. So confident, see, you know, nothing. Stop. Beach brow. I heard I'm get money who's a chasing over out. Chuchuka mbatinzi wani yesi. Inamwana chuza kana kuna chipanda chuzi chimusiwa. Sinishusha kuti boss. Zona wano boss. Ifuna mulibere. Wana sikutini veni wona. Veni vera sikutini vemu vera. Kambani. Waka pareti. Inamukana motiti kari. Makana pareti. Yero futu. Namure. Namure. Namure.